Hey, good morning.
How you doing? I was gonna ask you.
He's waiting for it.
I'm sorry.
Are y'all ready?
Yes, sir.
Okay. Good morning, everyone. The time is 9 o'clock, and I hereby call this January 17, 2024 Code Compliance Hearing to order. At these hearings, we follow an agenda which is available, and the first item on the agenda is the call to order. The second item is the pledge of the flag, so I'd like to ask you if you join me in the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. And the next item on the agenda is a note.
Good morning. If any persons decide to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
All right, item D on the agenda is the minutes for the December hearing. Are there any proposed modifications or changes to the minutes from the December hearing? All right, hearing none, I'm going to go ahead and approve those. And then there's a staff update.
Staff update, abated and continued cases are listed out front.
Okay. And that brings us to the current cases. I'm going to read a brief statement to you all just so you have some idea of the ground rules of how these hearings work. What I say will apply to all the cases, so I would appreciate if you'd pay attention to this. Good morning. My name is Christian Waugh. I'm a licensed Florida attorney acting as what is called a special master. That's a fancy title created by the law, but what it means is that Citrus County has hired me to preside over your hearing. What I'm going to tell you during this opening statement applies to all of your hearings. When your case is called, please come forward. You'll be placed under oath. If you are appearing at a hearing like this for the first time, I will state the alleged violation and allow the county to present its case first. You will have an opportunity to cross-examine any of the county's witnesses, and then you will have an opportunity to present your case regarding the violation. That will be your opportunity to present evidence and to make legal argument. It is important that you take your time during this process because it is likely going to be your only chance to make your case to me. At any time during the hearing, I may have questions of you, other parties, witnesses, or staff. Before I issue a ruling, I will ask if there are any members of the public who wish to speak. And if there are, such members of the public will have an opportunity, one, to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and made as succinctly as possible. Although persons may be upset or even passionate about what they have to say, all witness testimony has to remain civil. You should not interrupt other witnesses, parties, or attorneys. In most instances, if you are found guilty of a violation, the law requires that I give you a time to comply before any fine begins. You must abate the violation by that time, that is, fix the violation, or the fine will continue to accrue for each day that you remain in violation. The law allows Citrus County to impose the accrued fine as a lien on all of your property, and the county has the right to foreclose on that lien or to seek a money judgment against you after the lien has been recorded for 3 months. I encourage everyone here who has questions about their rights or remedies to seek their own legal counsel. In all cases in which I find that a violation has occurred, I will impose all costs required by county law. I incorporate this into all of my orders as standard provisions. If you bring your property back into compliance with the law during the time that I allow, that cost will remain minimal. But if you do not fix the violation, you'll be responsible for additional costs. Although it has only happened a few times in my years as a special master, I may continue your case if I find a need for further evidence or argument. Are there any appeals of orders to demolish?
Fine appeal.
There's a fine appeal, okay. Ladies and gentlemen, you do have the right to appeal any order that I issue today, and that concludes my statement.
First case on today's agenda, Jeffrey and Caitlin Saltz, case number 2023-01297. Code Officer Cody McGuire, page 25 of your agenda.
She's just gonna get her, microphone. She's a little too pregnant. No, I can swear you in while you're, Ms. Saltz, we're gonna swear you in while we're waiting. I'm sorry.
You don't have to stand up.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, ma'am. Thank you. You may sit.
Okay, good morning.
Morning.
Please proceed.
All right. Cody McGuire, Citrus County Code Compliance Officer. This is a repeat violation initially observed on June 23rd, 2023. The address of the violation is 1698 Rock Crusher, South Rock Crusher Road, Homosassa, Florida. Case number is 2023-129-01297. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31 of the Citrus County Code of Ordinances. The property owner is Jeffrey and Caitlin Saltz. Has been previously found guilty of the same violation at the same location on August 16, 2023. Case number 2023-00269 with $0 in imposed fines. That case was abated on September 21st, 2023. Good service via posting the property and posting at the Canto Government Building. I would like to authenticate the following documents and request they be made into evidence. Exhibit A, findings of facts and order acknowledging compliance from previous case number 2023-00269. Exhibit B, photos taken during my initial inspection on December 7th, and photos I took during my subsequent inspections on December 8th, January 5th, January 8th, January 11th, and photos of my final inspection on January 16th, 2024. Exhibit C, a copy of the notice of violation and hearing sent to Jeffrey and Caitlin Saltz, a copy of the posting affidavit, and a photo of the notice of hearing posted on the property in a pre-hearing order.
Okay. And so as of today, it hasn't abated?
As of yesterday, it hasn't abated.
Yesterday. Okay. All right, so ma'am, he's going to show you the documents he just talked about, and I'd like to ask you to look through those and let me know if you have any objection to them being evidence in this hearing. And are you Ms. Saltz? Yes. Okay. Ma'am, do you have any objection?
No,
No.
Yes.
I am having somebody, sorry, I found somebody.
And let me just, is that microphone working or, okay, I would
Yeah,
just try to
sorry.
speak into it.
I did find somebody that's willing, he's coming today to
Okay.
get all of like the bag trash and stuff like that for me today.
I understand. I just want to make let me deal with this first and then I'll hear what's going on.
Okay.
I have to read this first just to even understand what
Okay.
the case is. So give me 1 second. So I think I remember this case. Okay, so what's going on?
Okay. I conducted my initial inspection on December 7th and observed the property was in violation of junkyard conditions. During my subsequent inspections on December 8th and January 5th, 8th, 11th, and the 16th of 2024, I observed little change in the property. I received contact from Caitlin when she called the office. I explained to her that she was in violation of repeat junkyard conditions on December 13th, and as of my final inspection on January 16th, 2024, the property remains in violation.
Okay. So Ms. Saltz, because this is a repeat violation, they're going to be asking for penalties from the time that you fell out of compliance until the time that you bring it into compliance. Does that make sense?
Yeah.
Okay.
So me and Jeffrey aren't together.
Okay.
So I'm trying to work as much as possible, but obviously, like, it's kind of hard for me right now. So I did finally come up with money, and I'm having somebody. I found somebody online that's willing to come and get the junk, like the household trash and the
Right.
stuff that's in the front yard.
Right.
In the very beginning of my pregnancy, I was out of work for like 3 or 4 months. So like, I'm like behind in a lot of stuff, and he's not willing to help me. The stuff behind the fence is stuff that my ex left,
Yeah.
and I'm trying my best to come up with money to get people to come out and do it. I'm a single mom,
I get it.
and it's
Yeah.
hard. Now I am borrowing money from somebody. They're waiting for their taxes, which is coming in like 20 days. And they're giving me the money to get a dumpster to get the stuff behind the fence.
Well, I take it that you're telling me that because you want time in which to comply.
Like I am trying my best to get people
But like
to
I
help
said,
me.
so the issue here is that you already have a violation in the case, and I'm admitting these into evidence.
Yes,
The
sir.
problem is that because you already have that, it's an issue because the law requires that I assess a daily fine from the time that it fell out of compliance until you fix it. So, and I don't know what's the county's recommendation on this?
The Citrus County Code Compliance Division respectfully requests that the special master assesses a fine of $250 per day along with administrative costs to begin at the date you deem sufficient. From the date cost to begin on the date of the posting of the property, December 7th, 2023, and continue until January 17th. That would be 41 days at $250 per day, totaling $10,250. A fine of $250 per day from the day forward until the violation is abated. We would also ask that the special master find that it's the respondent's responsibility to notify the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Have you had contact with the property owner before this?
Just the one time.
Did they indicate a willingness to comply or to work on it?
The garbage went from being scattered along the front of the fence to actually in bags, but it wasn't in proper receptacles.
No, I understand, but in the conversations, did they indicate a willingness to help fix the issue?
Yes, sir.
Okay. So Ms. Saltz, this is what the recommendation is. I'm not necessarily going to follow it, but the issue is, and you may have other remedies that you can talk about to the county afterwards, but for the purposes of this hearing, I'm going to have to find that it's undisputed, frankly. Let me ask if there's any input from is there anyone from the public who wants to speak about this case? All right. So I've accepted your testimony as what I think evidence of mitigating, stuff that mitigates the impact or the guilt here, your inability to comply. What I am going to do is I will find that the property's in violation. I can't grant the time under the law to abate the violation because it's a repeat violation. I will deviate from the county's recommendation of $250 a day based on your testimony. I'll make it $150 a day from December 7th to January 17th. That's still going to be a large fine that ends up as a lien on the property if it's not paid. And from today's date forward until it's brought into compliance, it'll be another $150 per day. The second that it's done, I encourage you to get in touch with the county to let them know so the fine stops accruing.
Do they do like a payment plan? Because
I don't know the answer to that, but I would talk to the county both about ways to pay, possible relief, if there's a way to get out of this later on. That's up to them, okay? All right, that's it. Thank you.
Next case on today's agenda, Gerald C. Cruel, case number 2023-00164, Code Officer Brandon Norman, page 18 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please state your name, sir.
Gerald C. Crow.
Into the microphone, please.
Gerald C. Crow.
Thank you.
Good morning, sir.
Good morning, Doc.
I thought this case abated.
It has not abated as of yesterday.
Oh, okay. I mean, is this the case that I heard just a few months ago?
That's correct, sir.
Okay.
This is a fine appeal request by Mr.
Oh, it's a
Kroll.
fine appeal request. I'm sorry.
Yes,
I
sir.
thought this was, all right.
No, I apologize. This is a fine appeal request by Mr. Kroll.
Okay. So, Mr. Kroll, I think it's on you to explain, I mean, this is your appeal, so what did we get wrong?
What did we get wrong?
I think my understanding is you're appealing the fine that's assessed on the
Yes,
property because
yes.
the,
Yes, because
I
was
issued an
offered-
order.
Yeah, I was offered that by a letter from.
Oh, right.
Lori.
yeah, so you have the right to appeal orders, and you've exercised that right. My understanding is, and I remember our hearing, and I granted a time to bring the property into compliance. I think there were two cases, and I think
Yes.
one of them was fixed quickly. Is that right, Mr. Norman?
No, sir.
No, is the other one still out?
The
of
other one's still
compliance?
outstanding as well, but we're not at the compliance inspection date yet.
Okay, all right. So this is the other case, and so let me just take a look at this. Hold on.
I have the findings of facts as well if you need them, and the order.
I mean, I
opposing finding.
remember the case.
Okay.
What was the date of the order?
I'd have to look at it, sir.
October 23rd was the date of the findings of fact.
Okay, and then when was the order on the fine, imposing fine?
It hasn't been recorded yet. Before it's recorded, I send it to the respondent, giving them 20 days.
What was the date of the order?
Oh, actually, December 1st.
Okay, so it was timely appealed. That's all I'm curious about.
Oh, yeah.
I mean,
yes,
okay.
sir. Yeah.
All right, Mr. Kroll, I mean, what's the basis for the appeal?
I've been ill most of the time. I have recently I had a fall, and I'm seeing several doctors. First one is the cardiologist, and he's going to run a series of tests over 2 months. I have appointments with him, and I asking for some leniency.
In other
or
words,
help.
because of the medical complications, you were unable to bring, or to
Yes,
comply
but-
with the order in the time given?
Yes, it's very difficult for me to get much work done, plus the help, help was a problem because the situation is that the complainant that has not been reported, identified, but I know it's because she keeps running by up and down, honking her horn, hollering at the people, and a couple of the helpers, or, well, actually several of them, were immigrants, so they've been, had their citizenship, but they're sort of scared off by her.
Oh, I see what you're
hollering
saying. I see what you're
At
saying.
them, and that they were bad people, and I don't know, all kinds of terrible things. There was she put up a razor wire or barbed wire fence, string on there, and Mr. Norman suggested that I file a complaint to get it down, and on Christmas Day, she had somebody take it down finally, so I didn't get injured anymore, because there was, the wounds from that thing, when I was cleaning along the fence, don't heal well. There's probably some chemical or metal in it that's antagonist on there, so that's what I have there.
Well, I remember your testimony at the prior hearing that it was difficult, it was already difficult time-wise, just based on your circumstances.
Plus, every time I get an inspection, there's more things added on. Like now, the ordinance officer has the right to walk my line, the entire property, and I understand that's not acceptable according to the laws.
What's not acceptable?
That you can observe the property all around. You have to always observe the property from the public, not private land.
That's not true if they have permission to be on the private land.
That's what attorney had published on it that I found.
Well, think about it. If your neighbor has control over their property, and code compliance says, hey, can I go onto your property and take a look around and observe from there your neighbor's property?
Right.
Why don't they have the right to let someone on their property to look at the neighbor's property?
I'm not a lawyer, so.
No, but I mean,
yeah,
did your lawyer, or did a lawyer explain that? Because
Well,
there's no constitutional explanation for it.
Okay,
Right.
that's what they explained on it, plus it's a constant add-ons
Yeah.
of things that I don't know about, that I corrected. Ms. Laurie sent me originally the 6 pictures of the debris on there, which really wasn't debris. I had put them out there, covered them, because I was trying to repair the kitchen and the bathroom and things. It's an old house, and I had the stuff out there, so I had to take care of that. As far as I know, I got that all cleaned up, the original 6 items in the pictures from Lori.
Well, just
on
because
there.
I don't want to be unfair, I mean, I will say just briefly, addressing the prior point, there are things that code enforcement can't do even from a neighbor's property. You know, there's certain,
Oh, okay.
portions of a curtailage we could talk about
Pardon me?
that you have to have a warrant or something to go see. But I don't think what we're talking about here is a yard, is a lawn. So,
Oh.
does the county take a position on this appeal?
Do you have a copy of the administrative regulation for fine appeals?
I know, yeah, no, I mean, I know what the basis is for fine appeals.
And then whether a release can be accepted, whether the special master can grant a release.
Well, I'm just wondering what the county's position, if the county has a position.
There are two the first limitation is whether or not the violation has been abated. There's also a request for release shall not be accepted if the property owner did not use her best reasonable efforts under the circumstances to abate the violation.
Right.
And I used a tremendous effort. I worked every day I could on that.
Well, and that's why I'm
Certainly.
asking the county's position. I
Yeah,
think that
thank you.
both of those bases may have, my understanding is it's been abated, number one. Is that correct?
That's not
Oh,
correct.
this one? Okay, which is the one that's been abated?
There's neither of them.
Oh, okay, then I misunderstood the
Yeah, I
testimony.
apologize.
Okay. So as far as number one, it hasn't been abated, so that basis isn't there. There's testimony on the record regarding best efforts.
Yes, and I have brought pictures and things too.
Well,
Show
yeah,
my
that's,
case.
I would show the pictures to the county. Any evidence that you want to introduce, it's important to introduce
Oh, I
it
can,
now.
I can. Okay, thank you, Mr.
Well, could you show it to Mr. Norman and,
Should I explain it as we go, or what would you like?
yeah, actually, that's a good idea.
Okay. I'd like to do that on there, please. See,
And did you take these photos
yes,
yourself? Okay.
yes. And person that's helping me, he's in the computer, he printed them out, too. They're on my phone, nothing. And so I depend on this situation. First thing I'd like to show, this is what the property looked like before all the damage occurred from spraying pesticides on my land by the complainant.
Mhm.
And that brings up an important point. Under the Constitution, I am told that I have the right to face my complainant. Is that true here?
In a criminal case, it is
It
true.
is only criminal.
If you're a
case.
defendant,
Yes.
you have the right to face an accuser at your trial.
Mhm.
I'm not your lawyer. I encourage you to seek legal counsel.
Mhm.
But I will say that, that they are not required to appear at this hearing.
Okay.
Because the question is there enough
No, I
evidence?
just-
First of all, this is not actually a hearing over the violation. We found there was a violation. The time to appeal that has elapsed, so that's not even at issue.
Mhm.
The one issue here is there a basis for you to escape the fine?
Mhm.
So,
Okay. I'd like to show this.
no, I mean, I don't know if it's
That's all right.
relevant or not, so go ahead.
On the thing. But anyhow, this is the pictures before, on there, the plant, all along the road. There's actually plants and flowers. These are not weeds or anything.
So, sir, I will say this, I mean, this would have been relevant, it was relevant at the hearing, we went
Yeah,
over
and
it.
some of these pictures are repeat. Of
So the question-
137 that are in the record.
The question is there a basis for getting out of the fine because you didn't bring the property into compliance
Yeah.
in the time that was allowed? And I think you've stated those reasons on the record, namely medical reasons,
Mhm.
inability to get help, interference with the help.
Mhm.
So,
Yes. And
do you have any
That's-
photos of that, of those three things? Or do you have any medical documentation that
yes,
supports
yes,
your claims?
I do have that too.
Okay.
Let me find that. I had that down further. Oh, here it is. Here's a letter to my cardiologist. or
Okay.
Albert.
If you're willing to share that, you
Yes,
realize this is
yes,
going to
I
become.
am. It's
Sir, just
public
hold on a
record.
second, let me explain. So, your medical records, you have certain rights
Yes,
of
I
privacy.
understand.
If you
Yeah.
want them to be
Mhm.
introduced, they're gonna be public records.
That's all right.
Okay?
It's
So I encourage you to
nothing-
show them to Mr. Norman, and
Mhm.
we'll see if the county has any objection to them, and I'll take it under
This is
advisement.
just the first of the appointments that are scheduled right now. It's over a 2-month period for various tests because he says there's a lot he can do to correct the situation.
Okay,
There's also Dr. Kaushal, the retinologist, which I'm scheduling on him. I have yet to do. The other one is my GI doctor, which could be related to this because I get a sudden blackout and then I fall and I hit my head. So that's why I have to see the retinologist on there, and those are to be scheduled on there.
now, just one moment. Does the county have an objection of these documents being evidence?
No objection.
Okay, all right, let me take a look at them, and we'll admit them as Exhibit A.
Thank you.
Do you have any other documentation that you wish to introduce?
Yes, please. Also, well, just finish up with this because this shows the spraying of the poisons on my land.
Prior to our prior hearing, correct?
Yes, and through that period, too. This went on after the hearing.
Spraying. I
Yes,
mean,
she would not stop. on
how is
there.
that relevant for whether or not you were
Well,
going to
it
comply with my?
prevented me and
Mr.
made me-
Kroll, it will go a lot faster if you let me finish.
Yes, sorry.
How is that relevant to compliance with the order in this case?
It delayed me doing the work because I got sick from some of this, plus I had to work in this environment to clear it. She killed trees. See, I showed you the pictures here, and by the way, this is the complainant. She chased her off my land. Okay. The barbed wire, which Mr. Norman helped me with, and she took that down on Christmas. This is the fruit I grow, an example. Here's the fruit on a tree she sprayed, which is inedible now. And there's over 100 plants destroyed on my land.
When was the photo taken of the woman?
A month or so ago. I got the actual
And is that a
thing on my
photo of her
phone.
on your property?
Pardon me?
Is that a photo of her on your property?
No, she ran off.
So where
And
is
then
that?
she started taking pictures.
Where is that a photo of her?
That's on the roadside, a couple of feet.
Is it outside of your property?
Well, it's on county property, it would be road property.
What I mean is it a photo taken of her near your property? Is
Well-
it her in the act? What is that a
Well,
photo
I
of?
saw her in the act, but she ran off, you know.
Is that a
stepped off
photo
the
of her
line.
running off?
Well, yes, in a sense. Then she stood on there and took pictures.
Okay.
And I took pictures of her.
Well, anything you want to introduce, please show it to Mr. Norman, and then we'll see if the county has any objections.
Okay, I'll put them, here's all of them. I'm gonna have all of them for you. so that you-
And you've explained the basis for them. While we're going through this, I just want to know on the record, is there anyone from the public who wants to be heard on this case? Okay.
I got these two. I'll just show them quickly, because I know you're busy. This shows the damage from the spraying over the periods of time
Okay.
that this occurred. The dead trees. There's a giant paper mulberry, all killed on there, which was a very enjoyable thing. It's great big leaves. You can sit on it in the heat of the summer. See, that's one of the things that delayed me. I couldn't heal my leg very quickly. Plus, when I went out, it was 100 degrees. So it was a very difficult time, and, you know, I got no thing about it, but this is all the same, oh, I'm sorry, on there. But these are all things like this, spraying all along her side and along the road. And the worst damage was done in several places where I had blackberries, citrus, trees of various kinds, persimmon, all this type of thing were killed on there. So I submit these just as a group, showing you the damage that occurred. Mr. Norman wants me to clean this up, and I did clean most of this up. I don't know if he agrees yet how far I should clean.
We'll get to that.
You let me know, I will do it. I
Okay.
guarantee you I will do it, but I'm recovering now. If I only can get rid of this doctor stuff. Here, the other thing that occurred, and I want to point this out to you, and this is a gentleman from Seco. He's a certified arborist that's coming around, and he has, in about 20 feet of the right-of-way so far, they've chipped it all up. And I don't know if that's acceptable to the county or not
Thank
on
you.
there, but he says it is for his right-of-way. He has a rig that does this and chips everything up. And it's big pieces sometimes. I've been disposing of the big pieces.
Mr. Kroll, if you don't mind, does the county have any objection to these photos?
No.
Okay. Mr. Norman, do you know who this is?
I do not.
Okay.
Well, I did have a case on the neighbor's property. I've never met her face to face. I've only had interaction with her over the telephone.
Well, you were with her, talking for a half hour with her when she entered, after you got agreement from her to enter her property. That was her.
Did you receive permission from the neighbor to
Her
go
name-
into her
you want
property?
her name? I'll give you her name if you
Yeah,
like.
I just didn't, I don't recognize her in that photo. I apologize. She looked
Yeah.
different from the day that I actually spoke, she looked different from the day that I spoke with the property owner. I just don't recognize
I
the
mean,
person
well,
in
that's
that
okay. I
photo.
mean, you're not
Yeah.
under, do you recognize this as the neighboring property owner?
I don't think so, no,
Okay,
sir.
okay.
It is her. If you want the name, I can give it to you.
No, it's honestly not relevant for this
Okay,
hearing,
okay.
in my opinion.
I don't want to,
so
make
I
a
was just
case out of
curious.
it, but
We'll admit this as Exhibit B, Composite Exhibit B, and I am curious, Mr. Norman, to see a copy of the order, because he said it was 100 degrees out, so.
So I have here the affidavit of noncompliance. They're all stapled together,
Yeah.
that's why. As well as the email that Mr. Kroll requested the fine appeal, the cost breakdown for the fines and fees, findings of facts, orders imposing fine, as well as a posted email in his yard, because we never received good service. So I went to his yard and actually, I met with Mr. Kroll that day, and I said, hey, look, I've got to post this today. I have to give you
Yep.
some sort of notice. So
I
I'd like
agree.
to submit all of those if possible.
Fair
just
enough.
'cause they're all
I agree that I got the service on
Mr.
it,
Kroll,
so
I'd like
it's
to
great.
ask you to look through these documents and
Yes.
let me know if you have any objection to them being evidence in this case.
If I had a stapler remover, I would have just took the order out for you. I apologize.
It's okay.
Could I get a copy of these?
You do have a right to get a copy, but for the purpose of this hearing, I just want to
There's a
know
lot
if
of
you.
detail, that's all.
Okay.
Not all of them. I don't have them all. I got some. The first, let's see, the first 4 pages that Mr. Norman gave me, I don't have a copy of. But I have those, I believe.
So they're attempting to introduce these documents into evidence, so I want to give you an opportunity to look through
Yes.
them and take your time. If you have an objection to them legally, let me know.
Yes, thank you. Here's, here's something. Oh, yeah, and here's the notice. I agree. Lori sent me this email, and I agree with, the
Okay.
situation, and I said.
I understand.
I wasn't.
No, you're not, you haven't mentioned notice as an objection, so I'm not really
Yeah, the
taking it for that point. I just
No.
want to look at the order, and in order for me to look at it, I need to know if you have any objections to
Yeah,
it.
and I have none to these, but there's one that confused me. I had to go to the post office. My signature appeared on some documents, and it was not my signature. It was a scribble.
Okay.
And there's also a couple corrections on things, but it's the other case that I couldn't get. I had to call your office.
My office?
Yes, and your assistant helped me, and I got the vegetative order changed from 30 days to 90 days, which you ordered in court here last time. And I was sent a copy that marked it out and brought it over, but it's the vegetative case, which I understand is not here, but I just point that out to you.
Okay.
And the other item I have is SECO is coming back in this month or next with another certified arborist, where they will take out almost all the trees on the north side of the property. And this shows it, and I entered in the case there. And also, he invited you to contact him if you'd like. His name is Kyle Byington. Tyler Byington, excuse me, huh?
Are you wanting to submit that as well?
No,
Okay.
this is the original which he gave me. I don't know if I got I can
All right.
I can copy it
Mr.
down
Kroll,
for
so
you.
here's, I'm reading from, by the way, I'm gonna admit
I don't see the relevant.
the affidavit of noncompliance, order, et cetera, that you just looked through and that Mr. Norman has produced. But in the order, which I signed
I don't,
October
understand it.
23rd, okay, that I signed on October 23rd, 2024. And I remember this.
Yes.
You said, look, it's too much for you to do in a day, that the property was already substantially cleaned up and you only needed a little more time.
Right, but
I
then,
asked if 30 days was enough. You said it was, that it was more than enough. And look, things happen. I get that. So
yes,
I
things
think your
happen.
testimony is that things happened.
That's right, a lot of things happened, and I didn't realize that, because this is new to me. I'm not a legal person, and the things kept mounting up. I'd clear something, and then a chair was found on my porch that supposedly didn't belong there. I didn't know there was an ordinance on chairs. And there was another item where a chair was sitting out next to a pail of water. That was a violation. There was another order where the back was checked
Yeah, I mean,
out. And,
well, so for the
and
record-
some of those things have been there 40 years. There was a low-level covered area of
Well, see,
tile
that's,
roofing.
again, that's something that has to do with the prior case. I mean, in this case, I have
Okay,
two
okay.
issues before me, one
Okay.
of which is dispensed. It hasn't been abated, so that's not an issue. The
Yeah.
only question is, have best efforts been made?
Mm-hmm.
And let me ask the county, I'm actually looking for the reg. Can the county tell me where it is? Or do they know?
The administrative regulation, I don't know if you have a copy.
I may not.
I think we might have given it to you in a previous hearing, but I can give you my copy.
Thank you. So what it says in the policy is a request for release shall not be accepted if the violation has not been abated, period.
As of yesterday, all the 137 pictures that I received from Mr. Norman and Lori, I believe I took care of, but.
Well, understand,
apparently I didn't.
understand, here's the problem. Here's the problem. The amount of the fine hasn't even been determined yet because the property's not in compliance. That's why I can't even consider the request right now.
Oh.
So for example, if you had brought it into compliance yesterday, we'd know what the whole amount of the fine is.
Oh, I see.
Does that make sense?
Yes, it does, but I don't know
but-
what I need to fix. See, I thought I did it. I went over it, I looked at I went back to the library, put it on the big computer, looked at all the pictures, and I'm
What needs to
still
be
out of- I
fixed,
don't know
Mr.
what I'm
Norman?
on
What needs to be
compliance with.
fixed?
I can testify, sir, that I've spent many man-hours on Mr. Kroll's or on the edge of Mr. Kroll's property, trying to explain to him what needs to come into compliance. I went so far as to offer to come onto the property and actually walk with him through the property and show him, but every time I offered that, I was immediately denied.
Do you deny that?
Well, because the thing keeps changing.
All right,
See,
appeal
that's
denied.
why I don't feel it.
The
The
appeal's
previous
denied.
situations were
Mr. Kroll, the
different.
appeal is denied. You can't, on one hand, claim that it keeps changing, and if you are denying their request to even walk the property and help you understand what the violation is. I have to deny it anyways, based on the fact that the fine hasn't been determined, but I'm not even going to go back and look at the prior order because you're not working with the county to help you figure out what's in violation of it.
Well, I am working with them.
The appeal's denied. I don't agree with that. I don't agree
went
with
through
that.
all of them.
If you want this
What
thing to
else
go away,
can
you've
I-
got to work with them. Thank you.
Thank you, sir.
Next case on today's agenda. Andrew A. Macros, case number 218-9058. License and Compliance Officer Keith Gardner, page 20 of your agenda. Expert on the case, Sam Acosta, Certified Building Official, and Land Development Director, Joanna Katu.
What page of the agenda is this?
20.
20, thanks.
Mr. Macros,
Yes,
do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
yes.
Please state your name for the record.
Andrew A. Macros.
Thank you.
Good morning.
Good morning.
Good morning.
Case number 218-9058, Chapter 18, Article 1, Section 18A, Citrus County Code of, obtained after-the-fact permit for all construction modifications of the Citrus County Code of Ordinance. Address 1919 West Albury Place, Citrus Springs. Property owner Andrew Macros. Good service via posting of the property in the Ocanto Government Building. I would like to authenticate the following documents and request they admitted into evidence. Exhibit A, photos taken during the initial inspection On August 14th, 2023, photos taken during the follow-up inspection, October 10th, 2023, a photo from the property appraiser's website, and photos taken from the corrective action inspection January 4th, 2024, final inspection on January 16th, 2024. Exhibit B, a notice of violation, copy of the notice of hearing, a copy of the continuance letter, and a copy of the affidavit posted at the property.
So, sir, I'd like you to just take a look at these and let me know if you have any objection to them being evidence in this hearing.
What is this? This is my neighbor's property behind me. Oh, it's the easement, okay. These lines are grossly inaccurate.
Yes, yes.
And then you'll be able to talk about that. I guess what I'm just wondering is, do you have any objections? You know, in other words, once they're evidence, you get to talk about them. You can criticize them, you can call them garbage. But I can't really look at them until they're in evidence. And so a legal objection might be that they're not authentic. You think that they're not.
They are authentic.
Yeah, okay,
yes.
okay.
And then look at this.
Yeah, please, look, any objection you might have.
I agree with what they're stating, yes.
And you'll have the absolute right to comment on everything. Thanks. And is there anyone from the public who wants to be heard on this case? Just so I know now. Okay, yeah. You'll be able to speak, yeah. Right, then without objection, as to the evidence, I'll admit exhibits A and B. Yeah,
On August 14th, 2023, an inspection was conducted at 1919 West Albury Place. Photos were taken regarding a complaint of construction without a permit. During my inspection, I observed a barrier wall constructed around the back of the house. No contact was made with the owner at the time. The wall is on an easement and requires encroachment right to be able to permit it, which Mr. Macros is aware of. And he has stayed in constant contact with me regarding the application process, but because of the easement, he's had a little bit more time to try to move this forward. And until today, as of this morning, there are no building permits applied.
and so, Mr. Macros, I heard you talk about the lines. I assume you're talking about the property appraiser lines photo? Are you
The-
saying these are inaccurate?
Well, the picture that shows the line of the property versus
That's-
where the wall is,
That's
it's not that far off.
Okay, all right.
I know those are.
You admit
just
it's off, but not that far off?
Yes.
Okay. I mean, I think I understand the case. Are you contesting that it's on an easement or that you don't have a permit?
No, I'm not.
Okay. Ma'am, do you have
Well,
anyone with, okay, yeah.
I would like to state that originally I had a pool built in the backyard back in 1995. And as a part of a pool, you have to have a fence around it. And the property, because of the pool, I didn't realize it was gonna happen this way. Runoff was gonna cause it to have an issue. So I put a retaining wall in then with railroad ties. And just recently, I basically replaced the railroad tie wall, because the fence was there also, with something more substantial and more permanent. and the intent is to put a fence on the wall again. So I just, you know, I apologize for what I've done, and, you know, hindsight is 20/20. I wish I could go back and change it all, but I'm just trying to get the property vacated.
As far as mistakes in life go, this is not, you know.
Yeah,
that-
I know.
I mean, I'm not to make light of the regulations, but, you know, so I appreciate your testimony. If you do have any other witnesses, and I
Yes.
see someone who's testified here before, I welcome your testimony to talk about what's going on and
Shoot, yes.
what is going to happen.
Okay. For the record, my name's Brenda McKenzie. I'm with McKenzie Permitting and Consulting. My address is at 7232 East Gospel Island Road in Inverness. And Mr. Macros has hired me, and I have been working with the county. So he had the retaining wall that was there since 1995 with railroad crossing ties, and was replacing it in the same exact location that's been there since 1995, that it all along has been over the property line into the 30-foot easement that Citrus Springs platted when they first platted the subdivision. And it only encroaches about a foot, maybe a foot and a few inches.
Let me ask you this, what's the difference between an encroachment that encroaches 12 inches and 24 inches?
Okay, it's the same, I agree with you, I see what you're saying. But when I've sent the letters out to do the vacate, because I can vacate a paper road or anything like that, or an easement, but this one I'm only asking to vacate a portion of it, and it is a 30-foot wide easement, not like a 6-foot utility easement or a 5-foot one. So didn't feel it was severe, you're correct.
Are
Whether
you
it-
wanting to vacate just a portion of the
Yes.
30 foot? In other words, to narrow the easement?
We just
or
want
to?
we want to vacate that 1 foot, few
Yeah.
inches that he encroached over.
Okay.
We've sent I've dealt with Ms. Coutu for years, and the vacate process is to send a letter out to all utility companies, which we have no objections back from Duke Energy, Comcast, Mosquito Control
Wow.
Board, gas company, and I have, at Joanna's, at Ms. Coutu's recommendation, I've gotten with engineering, and they did have some questions with it being in a right-of-way, like, hey, we don't really like that, but now that they're looking at it, that it's a 30-foot wide one that's has had that encroachment since 1995 with no detriment to the easement or the property. I'm still dealing with engineering on getting that. Then we have to advertise twice in the Chronicle.
Yeah, I mean,
and
you can't apply for a permit yet.
can't apply for a permit until we have the vacate. I need to get the vacate through planning. Once that's taken care of, I can submit a site plan showing that. And then I also have to get an ownership and encumbrance
An
report
O&E,
from the O&E from the title company. Thank you. And not all title companies do that, but I do have one that does it. And then after that, we can apply for the after the fact. And I just feel with it being there since 1995 in a form, you know, that maybe that this is going to go through. But we can't apply for it until I have the
Yeah.
vacate.
We don't know.
And then I have to replat that one portion of Citrus Springs, I believe, that one unit.
What's the replat?
Then I have to replat that one unit of Citrus Springs, that unit, I think. Is it a replat? Not a replat, okay, then we could go in from there.
Okay. If a replat was involved, I don't know.
Right. Well, some that I've done in the past require a replat, some don't.
Interesting, okay.
Yeah, or a reconfiguration.
Has the county heard anything that it disagrees with, or is the county aware of anything, any reason why, to not be optimistic about this?
Yeah, thank you for the opportunity to speak. Joanna Coutu, Land Development. It is a 10-foot easement, not 30-foot, but there is an alley behind. I don't know if they have a survey yet on the aerials of, not the property appraiser, those are skewed, but the GIS. It might even be in the alley, I'm hoping not. It's very, very close. So I think the 1 foot and 1.5 foot might be off. It doesn't really matter, a vacate is a vacate. It would be part of or all of that 10-foot easement and hopefully not the alley. Takes
Right,
up
because
to-
if it's the alley, it's highly unlikely that,
It's not highly unlikely. I don't see that it's
Is it
being
a paper?
used.
It's
Yeah,
just a-
it appears to be paper, and it is a drainage and utility easement, which is why they spoke to engineering. I'm glad they did. No, I don't see any red flags as to why a vacate wouldn't be approved, but it's going to take about 5 to 6 months from submittal. It does take some time.
does the county have any immediate safety concerns, maybe with whatever's happening with impervious or water or drainage at this
Do
point?
you have any concern about a wall being in place?
It's the height above grade, and that is a walking surface, is that correct? Would that be a walking surface right by the edge of that?
Yes.
Okay. There should be a guard.
And what do you mean by a guard?
Railing to prevent someone from walking
I
off.
see.
Yeah,
When you say a walking surface, you mean the ground part or on the other side of my?
the high part, the deck.
My intention is to put a fence across.
What he's asking, I think, is
Right.
up to that high point of the wall, is it a surface where someone could walk, if they kept walking, they could fall off?
Correct, and Mr. Lacosta is correct, but our intent is to get this taken care of and then put a railing, so I don't know, did you want like a temporary railing until it's?
I'm
I
curious.
think that would be prudent
I
for
do
safety, yeah, prudent,
I do have a temporary fence up.
okay.
The only way to
I believe, is that
It's
the one I
around the
saw?
pool, yes.
That the
Oh, I
wire-
see it, I see it.
Okay,
It's
yeah,
a
no,
wire.
but that wouldn't serve the design criteria for a guard. Guard has to resist some 50 pounds per linear foot, and I believe it's like a 200-pound concentrated load.
Do we have to get a permit for the guardrail that we would be encroaching?
This is relevant.
Can't do it 'cause of-
We can't get a
Yeah,
permit for the
okay, so I
guardrail?
see the county's point. There's a safety concern because this fence is insufficient or otherwise they can't get until everything's properly permitted, the proper guard.
So at this point, I mean, I could say you could utilize it at your risk.
Yeah, and I don't, look, to be clear, I never want the county to sign off on something that's not done according to the rules. What I'm curious about is in giving the requested amount of time, I take your feedback for the nature of the danger that exists. So what we're saying here is if I do allow you the time to correct several months, no one's signing off and saying this is safe, you know? No one is signing off and accepting or assuming the risk, like, okay, the special master looked at this wall, he gave me 5 months to comply. The reason why I am gonna give you a little time is because it sounds like it's possible, you know? And if it can't be done in that amount of time, it's gonna have to come down, okay? In other words, if for some reason the county puts, not to, you know, make a joke, but puts a wall up against what you're trying to do, the only alternative is to bring the property into compliance by taking down whatever there is. What is the county's recommendation on this case?
Citrus County License Compliance Division respectfully requests that the special master assess a fine of $100 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. The amount was selected based on the actions of the property owner once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also like to ask the special master additionally find that the respondent's responsibility to contact the License Compliance Division when violation has been abated in order to allow for reinspection.
I am going to allow 6 months to bring this property into compliance. If it's not brought into compliance as ordered, a fine of $100 per day will occur. I make these findings based on what I think is the relative height of the wall being less than nearby trees, if someone's climbing up. But that's gonna be it. I incorporate other standard order provisions and that's it.
And that $100 is after the time frame that you're given?
6 months. So
Okay,
if
gotcha.
if 6 months have elapsed
Yes.
and either you don't have it
Right.
properly permitted or it's not taken down, $100 a day. Okay? Thank you.
Thank you.
Next case on today's agenda, Dylan Thomas and Morgan D. Bedwell, case number 2023-01186. Code Officer Cody McGuire, page 5 of your agenda. Expert on the case, Joanna Coutu.
Thanks, sir.
Yes.
Do you swear to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Can you please state your names?
Morgan Bedwell.
Dylan Bedwell.
Thank you.
Good morning.
Good morning.
Please proceed.
Cody McGuire, Citrus County Code Compliance Officer. Case number 2023-01186, a violation of the Citrus County Land Development Code, Section 4002, site development without a development order or permit. Address is 12189 West Acacia Drive, Chris River, Florida. Property owner is Thomas Dillenbed and Morgan D. Bedwell,
What was the address?
12189.
Okay, thanks.
Goods service via signed certified mail return receipt and posting at the Canto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos I took during my initial inspection on November 16th, and aerial photos taken from the property appraiser's website. Exhibit B, a copy of the notice violation, notice of hearing, and signed certified mail return receipt.
Okay. Ma'am and sir, I'd like to ask you to take a look at these documents. Let me know if you have any objection to them being evidence.
We have no objection.
Okay, thank you.
I do have a comment on them, but there's no objection.
Yeah, no, fair enough. Okay, then, just without objection, there'll be exhibits for the purposes of the hearing, Exhibit A and B.
I conducted my initial inspection on November 16, 2023, and observed the property had some trees removed. While researching the property, I observed that there were no permits applied for or issued. I have had contact with the property owner, Morgan Bedwell, after the notice of violation was received, and explained to her that she needed documentation from a certified arborist for the trees being diseased and or removed. As of my final inspection on January 16th, the permit has not been applied for.
Well, I guess I see it's interesting. On November 16th, there's this sign on there that says application pending for the development of this property. I guess that just means there's an application. Do you have an application?
We were getting our easement removed in between the two lots.
Oh, okay, all right. And do you understand what the case is
Yes.
against you? All right, well.
I was just waiting
What's
to-
your perspective? I mean, what's going on?
So, I wrote something up. In March of last year, we sold our home and bought two properties that were Lot 15 and 16, Block 14, Crystal Manor, Unit 3. We immediately had the properties merged, thinking that would be the correct action before putting a fence around our perimeter. I called the planning department to verify that we could put a fence up at this time, and they provided that we needed to do a vacate easement application if we wanted to fence the whole property, as we are not allowed to block any easements. We took all required steps to remove the center-lying easement, and that was approved. While we waited for approval for the easement, I asked what else we would be able to do. In the meantime, she proceeded to tell me we could underbrush and remove any trees that were dead or diseased and any trees 4 inches in diameter or smaller. We proceeded to underbrush the entire property the weekend of March 25th, 2023. We contacted a longtime family friend of ours, Chad Good, who is also an arborist, to give us his thoughts and expertise on which trees needed to be removed. He did this as a favor to us, and we proceeded to remove the trees he suggested around the beginning of June. I have also provided documentation of a letter from him stating so, and I have provided photos of the trees he discussed for removal.
You have photos of those?
Yes.
Okay.
And then we did this so we could see any low-lying spots within our property and how we would like to lay out our property to provide a site plan for future building purposes. With this, we have provided a code violation for the trees exceeding 4 inches in diameter on November 25th, and I spoke with Cody McGuire and provided documentation of these trees when asked. I've grown up in this area my whole life, parents, grandparents, and I have high respect for the neighborhood, and I would not want to depreciate other people around us.
Okay. Do you have copies of the documents that you had
Yes.
provided?
These are all the photos.
And while you're doing that, let me ask Ms. Katu, do you have any testimony on this case?
Yeah, Joanna Coutu, Land Development. It threw me off on the arborist letter. We've not seen anything. I just asked the code officer, there's nothing to file. That is a way to validate removal, but we haven't seen that.
Okay.
I can testify they have been very cooperative on all the vacate. They got approved by the commissioners in December. They're ready to go with the permit as far as applying.
Okay.
But I don't know about the arborist letter.
Have y'all seen the photos that,
Photos that they have. Have you seen their photos?
okay.
Yes, they have. I have an email stating so.
Okay. Do you have a copy of that email?
I can print it. I didn't.
It's not
print
that
the exact
I'm just
email.
curious if you have a copy. of it.
Yeah, I have a copy of me requesting the information they had and the pictures they had. I didn't receive those, so that is when I
When did
didn't-
you make that request?
It's here. I did not receive any code compliance photos. Can those be provided for review? That was
Is-
November 29th, the day I called
Okay.
on the,
Let's start from the top then.
Okay.
I want to see the letter
letter?
first,
Okay.
if possible.
yeah, whenever I didn't get those photos is when I didn't provide this. I had already provided all the photos to them and then asked for
What I
their
want to see,
photos.
can you show a copy of that letter to the
Mhm.
county? And we'll see if they have any objection to it being evidence in this case. Just let me know if y'all have any objection to it.
Chad Good is also on the board for Citrus County, and he said anyone is welcome to contact him if need
It's
be.
not relevant for this hearing.
Okay.
What's relevant for this hearing is, is there a violation of the code or not, you know? And while they're doing that, can you get the email that you sent?
Requesting
Yeah,
from
I'd
them?
like to see that too. Can you show it
Yes.
to Mr. McGuire and let?
Yeah. I sent it to Joanna, and then
Oh.
she said she was copying him onto
Okay.
it. So she had forwarded it to him.
Well, I'll read it. I just want to know if the county has an objection to it.
Do you have a signed copy of this?
I could get one. He sent it via email.
So he typed in his signature.
I mean, I have the original.
Well, is there a typed well, actually, I just want to know if the county has an objection to
We
it.
don't have an objection, and it is sufficient for them to do
His
what they did
contact
if we had a
information is
signed
on it.
copy.
I can get a signed copy of that.
I consider this a signed copy for evidentiary records. It looks e-signed to me because he put his name on it, so I'm not concerned with that. I'll admit this as Exhibit C, and I'll just take a look at it. Can we find out if the county has an objection to the email? I want to have that introduced as evidence.
Mm-hmm. I have not seen the code violation pictures.
It's okay. So y'all will.
Well, she said they provided is why it was.
I know, but y'all have to direct your comments to me
I'm
if
sorry.
that's okay. I understand that this can be. I'm sorry?
We were talking to you about that
Okay.
matter.
All right. And if you don't mind, let me finish, and then
Okay.
I want to be fair here. Does county have any objection to this?
No,
Okay. I'm going to admit this email as Exhibit D. I want to look at it real quick. I'm curious about a lot here. I mean, some of the things don't seem to match up in terms of timeline, but, is the county wanting to proceed with this case?
Not if you're accepting the
I
letter
am.
as
I
signed.
am. I mean, I have issues with some of the other stuff, but I don't need to reach those issues if I do think that letter is signed. Let me put it that way.
And Ms. Katu has stated it's sufficient for
Okay.
purposes of them cutting. the
Okay,
trees
then
down.
we're gonna dismiss the case. All right, good luck.
Thank you.
Next case on today's agenda, Edmund Trotter, case number 2023-00819, Code Officer Julie Wilkinson, page 32 of your agenda. Expert on the case, Joanna Katu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record.
Edmund Trotter.
Thank you.
Good morning.
Good morning.
Good morning.
Good morning. So this case is, we heard last month. So should I start from the beginning?
I'm gonna need a little I do recall the case, but I'm not
Okay.
recalling all the details.
This was the easement case,
And I think, did I send it?
the utility easement and. Yeah, it was,
The
yeah,
dog
well,
bite
it was
and all
brought,
that.
it was brought,
Did I
for last
leave-
hearing, but it was supposed to go for this hearing. It was brought up,
I do, I remember the case, I don't remember all the details, so maybe you should
Start from the beginning.
start, yeah.
All right. Case number 2300819. Fences, hedges, and walls, a violation of section 3150B of the Citrus County Land Development Code. Address 5359 South Marcia Terrace, Homosassa, Florida. Property owner is Edmund Trotter. I have good service via posting on the property and posting at the Lecanto Government Building. I would like to.
I think I continued it, didn't I, because I just want to understand why it's here, and I think I recall the reason why, but I don't want to guess.
Oh, because Mr. Trotter was not present.
Okay,
He wasn't noticed.
It wasn't
Right.
noticed.
I wasn't noticed. The date they had the hearing was December 20th. The
So he
date
was
I
noticed for
received.
today.
I remember.
Was he
Okay,
able to
I
see
got
it?
it. Yeah, okay, we do need to start from the beginning. Okay,
Okay.
good, all right.
I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on September 12th, 2023. A corrective action inspection on November 21st, 2023. Photos from a follow-up inspection on December 12th, 2023, and photos from a final inspection on December 19th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a copy of the posting affidavit, and a copy of the notice of hearing posted on the property. Exhibit C, a copy of the posting affidavit and a copy of the notice of hearing posted on the property on December 26, 2023. A copy of the special master order dated January 2nd, 2024. A photo of the order and exhibits from December 20th, 2023, and the YouTube link affixed to the door of the property. And photos from my last inspection conducted on January 16th, 2024.
Right, okay, so sir, I'd like to ask you to take a look at these documents. And you've already seen how this goes in other hearings. Let me know if you have any objection to them being evidence in this hearing.
Well, this one here is not my water meter.
Okay,
It's
I
not
mean-
even at a fence, so,
Okay.
I mean, if that's evidence against
Yeah,
me,
this,
it's not.
I remember, so this was the case where the HOA is involved,
There's no HOA.
or there's
It's
the
Hash
utilities, the
and
utilities.
He keeps claiming that my dogs attack him.
Right.
They're not able to get to the backyard.
Well, so let me explain. The reason why I didn't want to start the hearing completely over is because, that testimony is in the record. So I want you to be able to respond to it if you want.
I was told that it wouldn't
Well,
able
sir,
to be in
we're
the
not even there
records.
yet, so let me explain. So, the reason why is I didn't want there to be just a second, like a do-over. My opinion is that's sworn testimony, it's in the record, and you have an opportunity to say what you want in response. Now, we'll be able to cross-examine all witnesses again today, And, you know, I want to ask you that, do you have any objection to proceeding today at this
Yes, I
hearing?
do.
You do? Okay, what's your
This is
objection?
the second time this has been brought up by Mr. Hash.
Okay.
First time he pushed it was roughly 2 years ago. Matt Hampton, which I just found it was an officer prior.
Mhm.
I guess he doesn't work here from what she said.
Mhm.
He's already came out, inspected the fence and everything. There's a gate back there. He said everything is okay and never made it this far.
Okay.
So he's already approved of the fence and everything being back there.
He has no authority to approve it, but I guess what I mean you to say is he didn't find a violation.
Correct.
Okay.
So now all of a sudden there is a violation from what she's telling me. And, I mean,
Well,
I don't know which changed and from then and now.
So I get your point. I guess what I want to know is, do you have any objection? Because we heard testimony last month. Do you have any objection to coming here and doing it this month and you being heard and us proceeding?
Do I have a choice?
Well, not for me, but I mean,
Yeah.
if you have a legal objection, a reason, I'd hear it, you know? And we'll let other people from the public speak, but I'm curious.
I mean, from what I was told last week, that y'all couldn't put last month's testimony on record, and now you're telling me it was on record.
It was on record, absolutely. It was sworn testimony, people testified, you know.
Okay,
and
well,
so-
it wasn't supposed to happen because I wasn't.
I agree. No, I agree.
wasn't here, I wasn't notified about it.
So listen to what I'm saying. I agree with you. And so what I did is I'm incorporating everything from the last hearing, okay? So you have an opportunity, and I instructed the witnesses to be present so that you can cross-examine them if you wish, right? You can ask them anything you want, anything they said before, anything they say
Okay.
today, to preserve your rights.
Correct.
That's what I'm trying to do.
Okay.
So that's why I'm asking, is there any reason that we shouldn't allow that to happen today?
I wasn't here last time, so I don't know. I'm not an attorney, you know what I mean? And could we have Matt Thomas current? Or Matt Hampton, because he's the one that okayed it before. He represented the county.
He
at
didn't
that point
okay
in time.
any, so.
He
for-
kept me.
For evidentiary actually, I want to hear what he said to you based on your testimony.
He said there's
but-
no violation.
Well, let me
there.
back up. I will want to hear from it, but that's only if we're going to proceed today, right? So I'm interested in you, if you feel that your rights are prejudiced by proceeding at this hearing.
I mean, I don't know. I'm not an
Okay.
attorney. I don't know.
All right. So here's the plan. I want to, you haven't watched the video from the December
I
hearing?
haven't had time.
Okay. Then what we'll do is I will ask the county to reintroduce and go through the evidence again, okay? I'm still going to incorporate the evidence from the prior hearing. If there's a difference in the testimony between the two, that may be a basis for respondent to make an issue of later on. But for the purpose of this hearing, I'll ask for everyone to reintroduce their evidence, because the testimony on the record is that he hasn't had an opportunity to review the prior hearing. But now let's go back to the exhibits. I want you to let me know if you have any objection to the exhibits here.
Well, the first one, like I said, they're taking a picture of a water meter that supposedly that is not accessible. The water meter that's in this picture.
I take that as a relevance objection.
Okay. So it's not even my water meter that's the problem, so it's the issue.
Okay.
So I've even told her that we could move the fence. It's a gate. It's, when you open it up, it's not in the easement, it's 11 foot out of, and it's what, a 14-foot easement.
I'm going to overrule the objection based on relevance, because they do have testimony that talks about why it's relevant. We don't have to agree to it, and that
So
I
how's
want to
it
know what your
relevant?
comments are on it, but it's actually relevant for me determining what the issue is here.
So how's it relevant to me? I don't know. I haven't had time to look over this.
Okay. Please, if you can, go through is that your only objection?
I need time.
Yeah, take your time.
So I don't, like, more time than right now. I'm not gonna be able to go over this quick enough.
All right. So are you just not going to look through them and tell me, or?
What do you want me to do?
Sorry.
That's what I'm saying. I
do
can't
the
read
same
through this
thing-
right now.
What I want you to do is the same thing everyone else has done so far this morning, which is taking the time, and take what time you need to look through the documents.
Okay,
and
so
let
can
me
you
know,
recall me then?
Sir, and it'll go, honestly, it'll go easier if you let me finish, and I'll do the same for you. I want you to look through the documents and let me know if there's any objection to them. That's what I want you to do.
Okay, would you like to recall me then? So I have time to go over this?
No, you're up right now, and so I'll give you the time to look through them and let me know.
So I mean, I don't even know what I'm looking for in here. I don't know how to decipher this.
Well, look, I mean, I actually understand your point. I think it's a fair point, but that's part of why you do have the right to seek legal counsel as well.
Okay, can I do that?
Well, you've had the opportunity. You're here without a lawyer.
Okay, so can I get this continued then?
All right, so I take that as a motion to continue, and what I want to do is look at my December order. So
Okay,
that's in Exhibit C. Ms. Wilkinson, would you mind grabbing the papers?
So, I was told that that's a violation of my rights, that y'all held it without me here by Mr. J.C.
No. I didn't say, do you want me to?
No, I just want to see my December order.
Which one was yours? That one there?
Are they in order anymore? Or? Okay. Okay, let me just take a look at C. Okay, so for the record, what happened was this case was put on the agenda, advertised publicly for hearing for December 20th, but Mr. Trotter was not given proper notice of that, and he was given notice that the hearing would be for January 17th. When the county found out about that, they raised it to my attention, and then I issued an order staying. What I did is I stayed my order finding a violation. So I put that on hold. The county actually asked me to vacate everything from the December hearing, and I denied that request because I don't think that once people have sworn an oath and put something on the record that it can just be done away with. So what I said is the testimony and evidence of the December 2023 hearing will be incorporated into the January 17th hearing. And in order to remedy the prejudice, I asked the county to bring all the exhibits from the December hearing, to deliver a color copy of all exhibits to Mr. Trotter by mail within 3 days of the order. Was that done?
Yes, sir.
Okay.
It was taped to my door.
Okay, so you got them.
Yeah.
Provide a link to the video of the YouTube recording of the December hearing to Mr. Trotter. Did you do that?
Yes.
Okay. How did you do it?
It was printed on a paper, the link, and included with the evidence that I taped to the
Okay,
store.
which he's testified he got. Ensure the attendance of all witnesses from the December hearing at the January hearing, and if for some reason petitioner is unable to or believes it will be unable to comply with this requirement, inform me so that I would continue the hearing if we couldn't get all the witnesses back. And do you have all the witnesses here?
Yes, sir.
Okay. And then I say Mr. Trotter will have an opportunity to present his defense with all the rights normally accorded in any respondent in a code compliance case. If either petitioner or respondent have an objection to this order, or if respondent cannot view the video link, then such objection will be delivered in writing by Friday, January 5th, 2024 to Citrus County Code Compliance, care of Lori Spiros. Ms. Spiros, can you take an oath? And do you swear an oath to tell the truth, the whole truth? Can you raise your right hand? Do you swear an oath to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right. Did you receive any written objection from any party regarding my order?
No, sir.
So why didn't you provide an objection at the time you got
I
my
didn't
order?
see that I could look at the video or not.
Okay. So you didn't see the video link?
No, I didn't.
Did you see the photos?
I seen the photos, yes.
Okay. Okay. I'll tell the county, my inclination is to grant the motion for a continuance, but I would only do so if Mr. Trotter, you know, you've indicated that, are you going to hire a lawyer?
Yeah, I am. Because, I mean, this is the second time it's been brought up. It's been okayed by the county supposedly, or somebody representing the county said there was no violation. Nothing's changed. Now there's a violation. I don't see
And,
It's kind of turned more harassment than anything.
and, what is, so, you know, my position is, look, the county brought this case in December, and there's a bunch of testimony on the record. Do you want to vacate that hearing and get rid of the evidence from that hearing, or do you want to have a completely new hearing, which is what the county suggested?
Well, they haven't told me anything. I don't know.
What they
I mean,
told
I'd
me,
rather-
well, the reason why I bring it up is because I was trying to preserve your rights by
Right.
saying that the testimony in December isn't a nullity. In other words, that you'll be able to respond to it. And so, but the county actually was doing what you wanted, which is they were willing to do a complete do-over. And so is that what you want, a complete do-over?
Yes, I do.
All right.
I mean,
Does the
and-
county have any objection to that at this point?
No, Your Honor.
Okay. Then what I'm going to do is I am actually going to continue this to the next hearing based on the joint request, the prior request of the county and Mr. Trotter's request that this be done from the beginning at the February hearing. And you'll have an opportunity to present your case however you wish. I encourage you to retain counsel. And if you want any witnesses to appear, you're going to have to find them. In other words, the county is not under any obligation to find Mr. Hampton and subpoena him. But if you wanted Mr. Hampton to testify, you'd need to bring him, if that makes sense.
He represents the county, correct?
He does not.
No.
So, again, well, I'm telling you, it's your obligation to find, if you want. You know, and I hate to impose on all of y'all and make you come back for another, but I just want to fix the issue in a way that the parties are happy with, so.
Well, I mean, you say you hate to make us come back. This is the second time it's been brought up in 2 years.
Well, you have a choice. You can proceed with the hearing today, or
No,
you
I-
can go next month, and I've given you the option. You've
That's
said you
fine,
want
yeah,
it next
I
month.
agreed with that.
All right. Then that's it. I'll issue an order. Thanks.
Next case on today's agenda, Gregory and Jennifer Clark, case number 2023-01089. Code Officer Alan Jonason, page 6 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Sir? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please state your names for the record.
Jennifer Clark.
Gregory Clark.
Thank you.
Thank you. Good morning.
Good morning.
Good morning. Alan Jonason, Citrus County Code Compliance Officer. This is case number 2023-01089, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102. The address of the violation is 3109 East Patricia Lane, Inverness, Florida. Property owner is Clark Gregory and Jennifer. I have good service via posting on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 30 October 2023, photos taken during a compliance inspection on 5 December 2023, and photos from my final inspection conducted on 16 January 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the notice of hearing posted on the property, a copy of the posting affidavit, and a copy of the pre-hearing notice.
Ma'am and sir, I'd like to ask you to take a look at these documents and let me know if you have an objection to them. It was a good weekend if you're a Bucks fan.
Maybe, right? Yes, we already received these. I said we received.
Bless you.
these in the mail.
Bless you. Wow. I mean, just stop.
No objection.
Okay, thank you. Are they gonna win the next one?
I hope so.
Yeah. Would you bet money on it? I'm just- I haven't seen the line, but
Gotta have faith.
yeah, yeah. Yep. Okay. All right, then without objection, what's been proposed as exhibits, is it A and B?
A and B, yes, sir.
A and B are evidence. Just give me 1 second so I can kind of. Okay. All right, please proceed.
On 30 October 2023, I conducted my initial inspection and observed the property to be in violation. On 30 October 2023, a notice of violation was issued for special requirements for accessory structures, which is a violation of the ordinance mentioned earlier. On 5 December 2023, a compliance inspection was conducted with no change to the property. I have had brief contact with the property owner, but as of my final inspection on 16 January 2024, the property remains in violation. Land Development Director Joanna Catuz, expert witness.
Hello. These are very small lots in Inverness Highlands. Combined, it's about 1/3 of an acre. They purchased it in '92. The reason I'm saying that is they did get a house permit in 1996. That's the block wall, as you can see. Construction stopped. It expired. We have nothing since then, except for in 2004. It looks like they repurchased and then immediately voided. I can't find any details on what happened there, but there are no active permits.
So it's interesting, I mean, does that, if someone starts construction pursuant to a permit expires, is that I mean, that's interesting to me because, they're not storing it. What I'm wondering is, I mean, isn't that,
They have development on the site, and it does not have a valid permit now. If they would have continued, absolutely, I could buy that. But because it stopped and they never actually got a CO, they never got approval for recognition of something there. It's some kind of development, but it didn't finish.
okay. Well, so what's going on this property?
So we didn't finish because I got sick. I had cancer, and we just stopped. And just stopped.
Yeah, yeah.
But we are ready to comply and didn't know what we were supposed to do, if we were to take the structure down or whatever, but we're ready to comply if that's what we need to
So,
do.
I mean, I think the way I understand this case is that they're saying you can't really do anything on a property like this unless you have the principal structure there. So either you proceed and put a principal structure, like a house, or you get rid of whatever's there.
And
I mean,
we're ready to do
that's
that.
what y'all want to do?
We're ready to do that.
Do they need a permit to get rid of that?
Yeah, they'll need a demolition permit. Those are issued very quickly, so
Okay.
there's not like a delay for that.
So what do we do for it? Where do we go for it?
Are you going to take it
Demolition?
down, or are you going to have somebody hired to do it?
We're gonna take it down.
Okay, you just pull a permit, go to the building division, and they'll help you out.
Okay.
All right. I mean, about how long does it take to, well, does it abate when they get the demolition permit or once it's gone?
Once it's gone.
Okay.
Yes, sir.
Well, how long do you think it'll take you to get rid of that stuff?
I would say at least a month. We would
Yeah, it's
need
not
at
a
least
weekend
month
job.
that we
Not-
can-
Yeah.
Well, and the foundation is part of it too, and that's gonna be substantial.
Yeah, you're
So
right.
we would have to
The
have,
foundation would have to go as well.
okay.
Well, the reason why I ask is because I got to give you a time to comply.
Yeah.
And I'm
With
worried
the-
about that foundation.
With the foundation, it's gonna take us longer than a month to do. I was
Mhm.
just thinking that it was the blocks that we would have to.
Well, how long, do you have any guesstimate as to how long it would take? Because otherwise I'm going to guess, and that's a scary
Can we
thing.
hear your guess first?
It's not The Price is Right. I wish it was. I really couldn't guess.
Could we say 3 months just to?
If I could.
Yeah.
I think 6 months would be appropriate.
You do? Okay. Yeah, I mean, do you have any health, safety, sanitary concerns
sir.
out there? Okay. Then what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
What was the fine amount?
$50
It's 50.
per day.
And that's the lowest amount. Based on the county's recommendation, I will find the property in violation. Actually, let me ask this. Is there anyone from the public who wants to be heard on this case? All right, I don't hear anybody. Property is in violation. Give 6 months to bring it into compliance. If it's not brought into compliance as ordered, to fine it $50 per day. Okay? Thanks,
Thank you.
and good luck.
Thank you. Thank you. Okay.
Next case is on today's agenda. Case numbers 2023-01-225 and 2023-00846. No, excuse me. Case numbers 2023-00846 and 2023-00847. Code Officer Julie Wilkinson, page 23 and 24 of your agenda. Land Development Director Joanna Katu, expert on the case.
And Your Honor, this is a 119 exemption.
I'm sorry?
A 119 exemption.
Oh, okay.
Good morning.
Good morning.
Mr. Gozi, are your clients going to speak?
I will speak if I need any testimony.
Okay.
Okay.
Julie Wilson, Citrus County Code Compliance Officer, case number 2300846. A violation of Citrus County Land Development Code, section 4002, site development without a development order or permit.
And if we could, before you proceed, I just want to make sure that we have an appearance on the record. So, sir, can you state your name for the record?
Chigozi Offer.
Thank you.
Okay. Case number 2300847, a violation of Citrus County Land Development Code 4002, site development without a development order or permit. The address is in Citrus County for both cases. The property owner is Robert, spouse, and daughter Rupasinski. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos I took during an initial inspection on September 21st, 2023, and an aerial photograph from the property appraiser website dated June 25th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a copy of the notice of hearing posted on the property, a copy of the posting affidavit, a copy of the continuance letter, and a copy of the signed certified mail return receipt.
Okay. Please take y'all's time and just let me know if you have any objection.
Okay.
Ms. Wilkinson, so on Exhibit A, I thought I heard you say that there's photos from September and an aerial photo from June.
Yes.
And the most recent photos then would be from September.
My photos.
Yeah.
Yes.
Okay, all right.
The second one. The second one. Show me the same thing.
That's correct. That's correct. That's our property right there.
Okay. Okay, here's the lots.
Yep.
Okay. No objection.
Okay, thank you. And these are exhibits A and B in each case? Ms. Wilkinson? This is A and B in both cases? Okay, thanks. Perfect. Without objection, what's been proposed as Exhibits A and B in each case are admitted as evidence.
I conducted my initial inspection on September 21st, 2023, and observed that the property had been clear-cut. While researching the property, I observed that there were no permits applied for or issued. I have had contact with the property owners. As of January 16, 2024, no permits have been applied for. My expert on the case is Land Development Director Joanna Coutu.
Why are these redacted and with whiteout on them?
Because they're exempt under.
Oh, that kind of okay, got it. All right, I'm with you. All right.
And we're doing both at once, right? I think.
Yes,
Yeah, so
yes.
both of them are a little over a third of an acre. They're both as part of a master plan. They're single-family residential development, but we have no permits at this time.
Okay. Well, I think I understand what they're saying. So what's going on?
There may be another exemption. You know. So basically, on the face of the notice, the respondents here are asking the special master to dismiss this just on the notice because he hasn't made the prima facie case of tree removal, the permit that they are requesting with it. I have two exhibits that I would like to also include.
Yeah, if you would provide them to the county and we'll talk about them.
Just want to make sure that everything is the same. Because it shows a different depiction of the property and the lines.
And the way I'll do this is, once the county talks to me about that, I'm not gonna look at it yet. I'm gonna deal with your motion to dismiss. Because I don't need to reach that if I grant the motion to dismiss, but I definitely wanna talk to you about it.
Absolutely.
Yeah.
I have an objection based on relevance, and also, this is a copy of an email from December 2020 to some other people. I don't believe that it can be, that there can be, a foundation can be laid to
Okay.
do away with its hearsay nature.
All right, then like I said, I'm gonna leave it there for now, and I want to address the motion to dismiss first. So I take it, I wanna make sure I understand it exactly. You're saying that the notice doesn't provide a prima facie case for the county, I assume?
Yes. That's the position.
So the issue with a prima facie case is they have to show a prima facie case at the hearing, not in the notice. Now, the notice, this is and I'm just talking to you my understanding.
Exactly.
But a notice has to provide adequate notice as to what they're claiming. In other words, if the notice they give you doesn't put you on notice enough to defend the case, I feel after reading the notice, I mean, it lists the section number, it talks about the tree removal. Is there a basis to believe that y'all haven't been given, that you don't understand the case that's being brought?
No. In that case, I can get the misunderstanding. I'm talking about what is required or not required to remove, trees from a vacant property. So my client's position is that that does not apply to them. All right. The requisition of some permit does not apply to them because this is their homestead, and the properties that are being, where the trees are removed are contiguous to.
They're contiguous?
Yes.
Yeah. I did notice the addresses, they looked contiguous.
Yes.
But you're saying that both lots are together the homestead?
Yes.
It's gonna be developed as one?
Yeah, well, I mean, it's not even additional development. Is already, as is what he is doing. One of the requirements that he was supposed to have is perhaps a licensed, landscape architect in arborist. And some of the trees he was willing to keep. And it was at the suggestion of the landscape person that says, no, these trees are supposed to go as they are deceased.
Well, the issue here, though, is that it doesn't sound like there's any kind of, well, first of all, let's talk about homestead. I mean, is there a homestead exemption in the code for development? And if there is, does the county know?
No, there's not any homestead exemption
Yeah.
for tree removal.
So I'm trying to understand, how does the fact that there's a homestead apply here?
No, I'm looking at the land development
Yeah.
code.
I'm with you.
Okay. The exemptions, the very one, 5715.
5715?
A.
Okay, let me look at this. Okay, I see it's an exemption section, 5715. The following types of tree removal may be undertaken without a permit. Tree removal on residential lots of record developed with one or more habitable dwelling units. So that's the one that you're saying applies.
Yes.
But there is no habitable dwelling unit on the property. So how does that apply?
It does. That's their house.
Is there a house on the property?
Yes.
No.
On another lot? I mean, so the pictures of the lots I have are for 2 Maton Court and 6 Maton Court. Are those?
Please, don't say that.
Well, we'll undo that in the YouTube. But on the address, there are 2 adjacent lots. I still got the names on here too. Is it redacted out in front? Okay.
Everywhere else, we're gonna take care of yours after.
Yeah, you got to. There's no other option. What I want to ask is, it appears that these are both vacant lots.
So I believe they're referring to their home, which is on the other corner opposite from the clear-cut property.
Can you see it in that picture?
I can see it.
Yes.
Okay.
Okay.
So he's right,
Are-
there's 2 vacant lots.
Yes.
Are
so, yes, the two that
they,
they
but
cut.
we don't have a unity of title here, do we?
No.
It wouldn't apply anyway. Those are for building permits. So no, there's no unity of title and no ability to get one of those.
So I think, is it your intention, but I thought you all said that your intention is to build on these lots. Oh, it's not?
No, that's, so I correct me if I'm wrong. There's a development there which happened to be where they live, is their homestead. And I can supply the special master of case laws that indicates that because of the contiguity of the adjacent property, that makes it, you know.
I'm not, do you have the case law?
I do. If if you give me a moment.
Yeah, I'll give
look,
you a
I have
moment.
some-
I mean, I'm curious. Because those are not, these are lots of record. So, I mean, I'm just telling you my instinct at this point. Reviewing the exemption, we're talking about two separate lots. These are lots of record. They don't have one or more habitable dwelling units on it. Is the county aware of any application for a unity of title, or would that abate this?
There are no applications, and they could not get a unity of title. They'd have to have a permit and then try to get a unity of title to tie it together with another lot, but a building permit for a structure. That's where unity
So
of
they
title
can't do it
comes
if it's
in.
vacant?
Right.
They can't do uni,
It's with a building permit. It allows an accessory something on a vacant lot next to your house.
so maybe like an accessory use?
Yes, they want to put a detached garage over here. I don't know if this
But what
place
if,
allows it.
here's what I'm ballparking with you. What if it's like an accessory use of storage or being able to put a,
No,
So
unity of
that's
title
not
is a
possible.
structure, right. The one way they could have done this is to replat and make it one big lot. That
I
would have
see.
worked.
is, would a replat abate this?
No, because it's already trees, it's irrevocable, so
Okay.
it would be kind of after the fact on that. So the trees were there in June, in our aerial, so it was pretty
Well, I
recent.
guess, so are you saying that, you can't replat and remove all the trees, or?
I'm saying they could apply for a replat, but that would have been before the trees are removed, so the trees are gone, so it doesn't make them come back.
It's an interesting thing to me, yeah.
Well, even further than that, you know, the homeowners, they didn't have any intentions of just taking out trees. They also have plans of what they wanted to do with the place, and the trees have been ordered that are still coming, you know, regardless. So in the event that, that the special master does not agree with them, they need, you know, time to, you know, do some,
What are the plans on the property?
if, the,
Want me to speak?
yes.
Okay.
If, yeah, you know, I mean, please, I don't know.
Can I speak?
He has to
Go
be
ahead.
sworn in to speak.
Yes,
Go ahead.
exactly.
Do you swear to tell the truth, the whole truth,
Oh, I
and
thought
nothing
everyone
but
was.
the truth, so help you God?
I do. Okay, so we went ahead and took the trees out under the impression that we were gonna keep some of the trees there. We had them all taped up. There was like pink ribbons everywhere. Because my wife and I discussed it. We did not want to level the whole lot, either one of them. We had the company come out, that Hodges Tree Service, that come out and took out the trees. I told him, I said, I only want to take out the ones that were bad. He said, majority of the trees are down. He said, there's the potato vines on them. He says they were diseased. They were full of termites. There was holes in the trees. Looked like somebody just, you know, shot them with buckshot. I mean, they were bad. He took them all out. So I went by his understanding. However, I told my wife, I said, well, whatever they get taken out, because we were going to keep some, we're going to go ahead and replant trees. So our whole intention was to go ahead, sod the lot, irrigate the lots, put in new trees, which I still have ordered, and make it and beautify it for the neighborhood. And all the neighbors were like, yay, this is going to be great, because there's no place to walk the dogs or anything. So it was going to be a very much improvement of what was there. It was overgrown. We had coyote den living there. We had massive rattlesnakes that were in there, so we cleaned it out. But my intention was not to level the whole thing. That was by the advice of the tree service.
Okay. Well, I mean, so I think my question was, like, what do you intend on doing with the property?
We're going to just go ahead and put grass back in place,
Just grass.
irrigate it, and then go ahead and put trees. Yeah, nice trees. Replace all the trees on the property. So we took out the bad, put in the new. That's all we want to do.
And they're not gonna be able to get an irrigation permit on a vacant lot. So
It's coming off my
I appreciate
property.
the intent, but unfortunately,
Well,
They're
I went
separate,
ahead.
they're separate, and if you direct your comments
Yeah,
to me.
I went ahead and I asked, I talked to the young lady, and I asked her, I says, well, at this point, is there anything we could do? She says, no, we can't do anything about it. I said, what if we had joined the property? She goes, no, you can't do that this time. I would have no problem going ahead and applying to get them all to one, as one, and then put the irrigation.
Well, that's why I
on.
was asking a bunch of questions. It doesn't sound like that's in the cards unless and until you're able to pull off a replat. which is a process that takes, there's so many issues with plats. And fundamentally, the issue is that y'all basically cleared the lots without following the code section. But now, I mean, the issue that's been raised is, does the exemption apply? And I have to say that because the lots are not all condensed into one, there is no house on these lots, you know, so the exemption does not apply. What does the county want? I mean, what's the county's? And by the way, I'm going to set aside for a second the irreparable. I'm kind of interested in this irreparable issue, so I want to talk about it. But what's the county's recommendation?
Due to the irreversible nature of this violation, the Citrus County Code Compliance Division respectfully requests that the special master assess a one-time fine of $5,000 for each case, along with the administrative costs for each case. This amount was selected based on the severity of the violation.
So let's talk about the irreversible nature of it for a second. I've looked at the pictures of and I get it. I mean, I see that there were a bunch of trees there before and there aren't now. But they have testified that they would be willing to put trees back. Is it irreversible if they're willing to repopulate the lot with trees?
I think so, simply because the trees that were there would obviously be much more mature, much larger. You know, we don't have a tree survey to know exactly how many. The effort to replant, if that's part of your order, can certainly mitigate some of that fine, but it doesn't actually replace the growth that was there.
I mean, I don't want to get too far into again, no joke intended, the weeds, but you can always get a 50-foot live oak. It costs $50,000,
Yeah.
but, you know, and you have to put it in a bucket and ship it.
Right.
Maybe it's just from the villages, but whatever. I've never seen anyone do that in one of these cases.
Right, they usually are small.
I wonder, though, if I'm making a mistake by saying that it's irreversible. Of course, we're all unique. All people are unique. All trees are unique. Theoretically, every coin and every dollar you have in a wallet is unique. This is the one I got from the store. This is the one I got from my grandpa. But they're fungible in the sense that they're exchangeable. And with trees, I just wonder, is it irreversible if they're able to repopulate it? And I don't have a map of what these trees are or what they were.
Right. So the natural growth, I've got to assume, looking at the pictures, they were pretty substantial. So I understand, like I say, what you're saying, and the willingness, if it's part of an order to replant, we certainly can look at that as well, but I don't think they're going to be able to accommodate what was there before. And unfortunately, we're not at the point where it's so many trees per development, because there's no development at this time. It doesn't sound like there will be in the future, so that would be an option, but.
Recall also, and prior to you issuing your order, I intend to ask if you could stay for me to furnish you with and also for the statute 196.031, tend to do that, and I tend to suggest that
Florida statute 196.031.
says it extends to homestead exemption in addition to the home. The case law that I'm referring to, this is a person who bought a lot next to their building, and they were able to certify that that was contiguous without having to do any replotting or anything to that situation. And if you consider that, consider also the fact that they not only didn't want to cut down all the trees, they were advised based on what they were only required to do if the special master were to find that this was their homestead and that they have a residential building on it. All they needed was an advice of an arborist or a landscape architect. And it's based on their prompting that they cut down trees. And their intentions to replant is already in process. They have already ordered, and I have documentations here that show what, trees that are on order, that are coming. This is without the special master's order. They're already doing that.
Let me first address the homestead exemption. I've now reviewed the section, and I think you're referring to subsection 5, which says, for the purposes of applying the exemptions, not any other purpose, but it says, for the purpose of applying the exemptions in this section, the real property includes portions of the real property and contiguous real property assessed solely on the basis of character or use pursuant, and it's a bunch of ag exemption type stuff. So I don't find that that applies. But I'm trying to also, I think,
And if I could just address
Yeah,
anything.
please.
At this point, they were cited for site modification, which though site modification includes tree removal,
Yeah,
that's not the only.
it's more than that, yeah.
It's not the only thing that was
Right.
done here. This was a complete clear cut.
Right.
Everything's gone. I don't have this picture in front of me, but I think it's just dirt at this point
Yeah,
onto.
it looks leveled almost.
Correct.
Yeah.
And leveled is not how ground usually is naturally in Florida. So again, we have the water runoff issues, all the things that go with site modification.
Right.
So while we appreciate the fact that they want to put trees back and it's encouraged and accepted, it would not ameliorate the issue that they're actually cited for, which is the site modification. So at this point, that would be the county's position.
You know, I actually thought of that myself, but the thing is on the notice, what it says is tree removal is not permitted on vacant land. Corrective action, obtain building permit or site development order by November 4th, 2023. I take the county's point. I mean, I agree. But it like seems like this really drills down and specifies on tree removal. So I'm wondering if this is a proper notice for anything besides tree removal. I mean, but I don't find that the exemption applies. I don't find that the homestead exemption applies, so what am I left with?
Consider also the fact that he indicated some of the dangers that, and
Yeah, and I think that's that's evidence of mitigation, for sure. And I, as well as the intent of what they're going to do with the property, I find that to be mitigating.
Right. If you will also look at, when you do prior to your order, there was an email there with somebody from the board communicating that they did not need that permit. But I'm okay with the county's objection to it. But it goes to their state of mind on whether or not they were supposed to get a permit or not. Their neighbor, the same thing happened to their neighbor who did not have any fines.
I don't have any evidence of that.
That's the one we objected to based on hearsay from their two documents.
Oh,
We
okay, so
objected.
yeah.
We
So
objected. You haven't
So I
made-
dealt with the motion to dismiss. Let me deal with your evidence.
Yes.
I will admit this as relevant. I think it's relevant because of a potential defense against equal protection. But because it's not from a governmental authority on this property, and it's also not it's really not on this case. In other words, they didn't rely on anything. And code enforcement changes case. They are allowed to go and do different, whether you like it or not, but so I find it relevant, and I'll admit it as evidence, and if you want to appeal, it'll be a part of the record, but I don't find it dispositive. I do also think it bears on mitigation.
I agree, and if I would, I'm glad you mentioned equal protection, because my client and his neighbor, they were similarly situated.
Yeah.
The same things happened on both you know.
It looks
properties.
similar, I
So,
mean, but I didn't rule in that case
Yeah,
either, and so.
I agree.
So what is, I heard the county's recommendation. Is there anyone from the public who wants to be heard on this case? What I'm gonna do is I am gonna find that the properties are in violation, but I do accept a lot of mitigating evidence that's been presented. So instead of finding a fine of $5,000 on each case, I think what I'm gonna do is find, $2,000 on each case, and that's what the fine will be.
And we need, what kind of time frame, we need?
So my understanding, actually, that's a good question. My understanding is that it has to be paid in 3 months or it becomes a lien of record, but that's a good question. I don't know, how soon does the county want that kind of thing paid? Well, I'll put it in my order, I guess. I'll put it in my order.
That's I
What do you
just
want?
Want to make sure, the payment, if we do not, appeal it or any, is this, the payment will be dispositive of, the county?
It goes, it's the one, that's
one-time
the,
fine.
that is the fine for the violation period. So it's not something that goes day by day. It's a one-time
One-time.
fine, and that's it.
But they want to be friends with the.
Oh, I know. I mean, I'm glad to hear
They're
that.
not- Trust me, they're not.
No, and you all haven't come in here and kicked the door down, you know, so.
No, these are good people. The
Yeah.
county people, I respect.
No
This
one's
is-
accusing you of otherwise.
Trust me, this is the good people trying to do the right. There's
Can
all kinds of confusions with the HOA and all of that, but
Can I just say one thing?
Yeah.
Is it possible that maybe we can meet you halfway so we could take that extra money and put it into the trees and everything else on the
Well,
property?
I've already gone more than halfway based on the county's recommendation. They recommended $5,000 per case.
Yeah.
I-
I was talking about okay.
yeah, you.
So you
should've
got
told-
40% of what they were, I mean, I mean, I'm trying, so it's a violation. And so there's also precedent. I try to stay relatively equal for the same violations on other properties. You got less than what I did at the last hearing, which is 2,500 per. So anyways, I think that's the end of the hearing.
Okay.
Good luck.
Thank you so much.
Thank you.
Next case on today's agenda, Warren Beal Foster Jr. and Samantha Megan Foster, case number 2023-00930, Code Officer Brandon Norman. Expert witness on the case, Land Development Director Joanna Coutu, page 14 of your agenda.
And my understanding is one of these cases already abated.
Yes,
Yeah,
sir.
We're only, okay.
Yes, sir.
Ma'am? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Can you please state your name for the record?
Samantha Foster.
Thank you.
Okay, good morning.
Good morning.
Good morning. Brendan Norman, Citrus County Code Compliance Officer. This is for case number 2023-00930. Fences, hedges, and walls, a violation of section 3150 of the Citrus County Land Development Code. The address is 13210 South Oakview Avenue in Floral City, Florida, 34436. Property owner is listed as Foster Warren Beal Jr. and Foster Samantha Warren. I have good service via signed certified mail return receipt. I would like to authenticate the following documents to request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on September 28th, 2023. The correct faction inspection done on November 1st, 2023. And photos from my final inspection done yesterday, January 16th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of a continuation letter, a copy of the signed certified mail return receipt.
All right, so ma'am, I'd like to ask you to take your time and look through these documents. Let me know if you have any objection to them.
Okay. I understand the fences. What would be considered hedges and walls?
I guess we'll get into that. I mean, what I'm curious about really is on the photos, do you have any, in other words, they're gonna use these photos as proof?
And
okay? And you have a
just-
right to comment on those?
Yes.
You know, but do you have
It's
any,
all removed. We missed a small section. It was about an 8-inch section. I removed all of the fence because Warren Foster, who we got divorced in 2019. Him being a great dad, I allowed him to move down to Florida 3 years ago into my home. And he didn't want to remove the barbed wire because the person who filed the complaint actually installed the barbed wire. So,
Well, Ms. Foster, and we can get into that.
but I removed it, but I had a bit of a problem. The part of the tool that you remove the nails went right into my lip 2 days ago. So I had Warren remove the rest of the barbed wire. He missed a section, and it's hard to see on the other fence line.
Well, I want you to be able to talk about it, but first what I need to know is, do you have legal objections to these documents? I know you want to talk about them, but I can't talk about them until they're evidence.
I mean, legal objection,
Are they inauthentic? Do you think they're
no,
not
they're
of the
true.
property?
They're completely true.
Okay.
And I would love to talk about. So yes.
I get that impression. So
I mean, I can't be long. I have a 6-year-old. I'm also sick. I have ovarian cancer for the second time, and my
Sorry to hear that.
6-year-old has severe lupus as well as 2 periodic fevers. So I just got a call. That's why I rushed out. I got a call from the school. She has 104 fever, so I have to.
That's important.
Get
Okay.
her, but this is important because.
Well, I'm trying to get through it,
yeah.
so that's why if we just handle the questions
Yes.
quickly, we'll get through it quickly.
And I have lots of proof, so.
Okay, great. So do you have any objection to these documents being evidence?
No, I don't have objections. It's true.
Okay, that's
so-
fine. Then we'll talk about them. And is there anyone from the public who wants to be heard on this case? I don't see anybody. Okay. Now, based on what you've put on the record, if you feel that, I mean, are you under duress right now? Are you able to?
I'm not under duress. I can.
Okay.
I can handle.
You can speak, all right.
I can handle this.
Thank you. All right, so without legal objection, what's been proposed as Exhibits A and B are evidence, and I want to hear what the county has to say.
Of course. On September 28th, 2023, an initial inspection was conducted of the property for a fencing violation, a land use violation, and for junk and debris. The property was found to be in violation of both junk and debris and the fencing violation at the time. Later, I spoke with Samantha Foster, who informed me of approximately 20 goats and 10 chickens on the property. She stated that she would not be removing the animals that were in violation, but later she has come into compliance for the junk and debris as well as for the land use
I say
violation
there's
for the
no
animals.
such thing as too many goats, but I know some people here
Well,
disagree with me.
Thank you, but and I never said I've never had more than 14, so I don't know where he got. I said I had 20 chickens.
That case went away,
20
so
chickens.
You're out of it.
So she did come into the compliance for the other 2 cases, which we really appreciated. I re-inspected the property on November 1st, 2023, and found that barbed wire still remained. As of my pre-inspection, or pre-hearing inspection that I did yesterday, January 16th, 2024, most of the barbed wire had been removed.
You agree with what she testified to?
I agree. A lot of the barbed wire had been removed. There was a section that had remained.
Okay.
It was more than 8 inches. It was a significant amount, in my opinion, as well as the director's opinion. That's why we moved forward with the case.
Okay, so I don't, whether it's the amount testified to by you or the county, I think the only relevant question for my consideration is how much time do you need to finish the job? You don't need any.
Oh, it was all taken
Okay.
down.
So you don't need time?
I've called this office several times within the last 3 years because I'm not the type of neighbor to complain or whatever. I try to fix the issue and help them. And my neighbors on the Hernando side of me, there's an old fence separating us, and we want to put up new fencing, which Brandon saw that is the fence line that had barbed wire. Most of it's really hard to see because of the fact all of their trees and brush go through all of it. So it's really old barbed wire.
But you're telling me it's done?
Yeah, oh yeah, I have pictures. I just had my ex-husband Warren Foster send all of the pictures right now because he didn't print out things like I printed things out last night. So, but yes, it's all removed down. He removed all of the brush. that is on that fence line, the years of vines that are entangled with the barbed wire. So I'm,
Okay.
but yes, and due to your comment about goats, I appreciate that, because I did look up, I know that the animal case was dropped. I do have a picture of the junk and debris, which was one tree that was cut that was infested with ants, and it was about to fall on my neighbor who has a tree farm. It was about to fall on his fence. That is very good fence, no barbed wire on that fence, and it's on our property. We allowed him to put it 2 feet on our property. But yes, it was about to fall. It is not 74.6 inches in diameter. You can see that it is split. And this was all at the time that I had, I like to do a lot of free work for disabled veterans and stuff with tree work, like trees that are falling down or split wood, whatever. Nothing that would need a permit. But I had surgery, I had a cast on my arm, and I was told that I needed to stack the wood nicely per Brandon. Just stack it, make it look pretty. So I did that with a cast on my arm. As you can see in the picture, my goats, 2 goats. The largest goat here, which weighs, he
Well,
was,
ma'am, I
he was
love goats,
castrated
but
last year.
We do have other hearings. so-
60,
For the sake of it,
65 pounds.
we're not even hearing those cases, sir.
No, I get it. I know,
This is
I
only for the
understand.
barbed
So, back to the barbed wire. This is as of last week. This is why Citrus County Sheriff's Animal Control advised me to put the barbed wire at the end of at the bottom of the fence line. This dog has caused $6,000 worth of damage, meaning vet bills, injury to myself, by digging in, killing animals, killing a goat, and I had to put my service dog down, and that's when Animal Control came out and told me to put up barbed wire at the bottom of my fence, because the neighbors who filed the complaint, their pit bull is always out, and I have tons
Well, look,
of messages about
I've got
that.
the code section here, I know what it says, I understand your reasons, but you've already testified that it's come into compliance.
The fence is in compliance, but I'm still not happy that my neighbor's fence is still not in compliance.
Well,
It's been 18 months. It's been 18 months.
If it isn't,
I-
you can make a complaint.
I had to remove my house from selling it.
All right, so this is an issue where, as of yesterday, there was, according to county testimony, a violation, however minor. And the testimony today is that it's already been fixed.
Yes.
What I'm going to do is find a violation for the purposes of asking code enforcement to go verify it and then get rid of the case.
Understood.
And if it's not brought into compliance within 7 days, let's say, then a fine of $50 per day.
Yeah, I
Understood.
can show him
Yeah,
pictures right now.
and that's all it'll take,
Yeah.
okay?
Great, thank you, sir.
All right, that's it.
All right,
Thanks.
thank you.
Next case on the day's agenda, Rita Dietrich, case number 2023-01049, Code Officer Brandon Norman, page 8 of your agenda.
I would just get in touch with the county. You can talk to him whenever he's available.
Ma'am,
Yes, ma'am. Him too?
if he's gonna speak,
Yeah, he's gonna speak.
do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Absolutely.
Please state your names.
Rita Dietrich.
All right, thank you. Good morning.
I am the owner of the residence.
Yes.
I have Fred and Janice Lawson and their son Glenn, who reside with me as my roommates. Most of the complaints are being forged against the work that he is doing on property. I have let it occur because he is unable to work due to a back issue. Therefore, he does what he can to help supplement the income.
Now,
He's-
ma'am, just so you know, usually what I do is I let the county present its, the reason why I let
Okay,
the county
okay,
present their
yes.
case first is that I don't even know what's,
Okay.
so when you're talking, I
Yes.
don't know what you're talking about
Okay.
because I don't know what the
Okay.
county's doing. But, I
I
mean,
understand.
what I would say, and this would be true for anybody here for hearing, I mean, if it's your intent to concede that a violation has occurred, then I don't really need to go through the whole hearing. I can stipulate to a factual record and say, hey, what's the county's recommendation on this? Do you want to give is 3 months enough time? You know, that kind of thing. Are you conceding that a violation is on the property?
At this point, I'd like to defer to Glenn, who's
Okay.
got
That's
that, and then
fine.
we can take it from there.
Property's clean, everything's done as of this morning.
All right, so that's not a concession. What's the county's case? I'll
I
listen to the.
removed everything.
All right, I hear you, and we'll get to it then. That's not a concession, so the county can present its case.
Thank you. Brandon Norman, Citrus County Co-Compliance Officer. This is for case number 2023-01049, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. This address is for 9200 East Wynwood Loop, Inverness, Florida, 34450. Property owner is listed as Dietrich Rita. I have good service via signed certified mail return receipt, and I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on October 19th, 2023. A corrective action inspection done on, done on November 16th, 2023. And the final inspection done yesterday, January 16th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt.
Okay, so sir, I'd like to ask you to take a look at these documents and let me know if you object to them for any reason. And
Yeah, I kind of objected. He's on the neighbor's property and we're friends with him. I know he didn't have permission
Okay.
to come up from there. Number one.
Did you have permission, Mr. Norman?
The property that I inspected it from is vacant, and there's
No, it's not
there's
vacant. It's
no,
part of it.
no trespassing
Certain-
sign.
just yeah, let's not, I asked you, and only you, a question, Mr. Norman. What was the answer?
The property that I inspected, the 9200 East Wynwood Loop from, is a vacant property, and there's no trespassing signs posted on the property. So I'm able to use the vacant parcel in order to observe any violations that are present.
How is that true?
May I speak?
No, I mean, I'm just curious if the county has a position regarding not needing a property owner's permission to take photos or go onto the property.
If there's no domicile or anything on the property, there's no one to make contact with to ask permission.
You regularly
And it's our-
regularly get in touch with people who have vacant lots who are respondents in these cases by sending them mail.
I understand that. It's our policy that when we conduct these inspections, that we're able to go onto these vacant parcels when they are vacant and there are no trespassing signs. We're allowed to use those in order to view those. That's what I was directed
That's
to do.
interesting.
So.
Now, are there members of the public who want to speak on this case? All right, then I'll let you all speak. Are y'all the owners of the vacant property? Okay.
I gave him permission to go on my property.
Okay. Another, on a different property. Okay.
And none of these, so.
That's interesting.
The property that he's referring to, the house is right next to it, and they own that whole wooded area all the way to it. And it's apparent,
Which is adjacent.
Well, what I want to know is what photos were taken from that property.
every one of these,
That
right?
he'll,
Every one of them.
well, we'll get into that.
Okay.
So you've made what I consider a valid legal objection to photos. Do you have any objection to anything else?
I work on tractors and stuff like that, and I spoke with him last time he came out, that, as long as it wasn't visible from the road, it was in compliance. And when you work on tractors, you cover them up so they don't get wet, you know what I mean? Working on customers or friends or whatever. So that's what the tarps are for. And last time he came out, he said that was fine.
I don't agree with that, but that's for the merits. I just want to know objections to these exhibits right now. By the way, you said everything was cleaned up anyways.
Yeah, everything's
so-
gone.
The
Yeah.
bronze
filled-
bin has been filled in.
Yeah, it's already filled in.
The only thing that is out in the back right now, and what I would like to say is when we met with Mr. Pearson, who is the original code enforcement officer, and he has since retired.
I'm aware.
He had told us, as long as it's not visible from the road at the front, if it's behind the house where it's not visible there, and we have covered it, then it was acceptable. That was our perception of what he explained. right or wrong. And that's where we were. We were not aware that if it was the back, there's a road and the subdivision behind us, that you could go there, if you look there, and you could see anything.
Okay.
But it's so wooded, we didn't know, and we covered it. The only thing that was not covered was the burn pit at the time, because it was in process of either being burned or having debris brought in.
Right,
He was
right.
working on the neighbor's lawn.
Right.
With this last week, it had filled up, because they were helping the neighbor with an area in the front of their yard, and he was putting that in there.
It's
and-
filled.
And, yeah, and it was filled, because at the time, we had talked a bit after I got the notice, and basically, he said he would fill it in, so that's what he was in process of. But with the rain, it kept, it messed up, so we covered it.
Okay.
Is the way I understand it. Glenn can fill you in. I've just been so stressed, I've been back and forth, so
Okay.
my.
I took the top of it off this
Yes,
morning.
I'll let you-
It's all leveled out now.
What's leveled out?
The fire pit,
Oh, the fire.
you know, it's 8 foot across.
All right, well, we're not even there yet because I haven't seen them, but do you have any other objections to the actual exhibits?
Like the one here where you see the carport being built, that's under construction right there. I mean,
Okay.
because the lady next door, which is.
That's a
in the-
comment on it, and again, we're not taking those up. I need to know, and you have the right to comment on all that stuff once they're in evidence. Do you have any reason to believe that these photos are inauthentic, that they aren't real, that they're doctored or created by an AI?
I don't see a mess here, I
That's
really
illegal,
don't.
so again, that's something I'm not asking about. So I just want to,
don't understand.
let me make it more clear, that's fair. Let me ask you this. Do you think that hold on, ma'am. Do you think these photos are doctored in any way?
Oh, no.
Okay.
Right.
Do you have any reason to believe that Mr. Norman didn't take the photos?
No.
Do you have any reason? And now you've already made one object that I haven't ruled on.
Right,
I'm going to
right,
deal with
right,
that.
right.
But do you have any reason why that should not be evidence in this hearing?
No, I just didn't think that there was a number of tractors you could own.
Okay.
Or in your backyard, it's your backyard. I mean, it doesn't even.
A
feel
lot of
like-
people believe that.
It doesn't even feel like it's our backyard.
Right.
Really, like the other night,
Well, listen.
I can't have fires.
I do this at a
But
lot of my
everyone
hearings.
around me
Look at
has
all these
fires.
rules. Look at all these rules. So
Yeah,
I
But we're not a gated community.
I'm going to say that there's no other objection besides the constitutional one, which I'll take up.
I feel,
But could the county attorneys now take a look at these documents?
I feel like my civil rights are being,
It is a civil right, actually,
I
the
mean-
Fourth Amendment, so.
like, every time I have a fire, they call the fire department. And everyone around me the other night had a fire. You know what I mean? Here I am, I can't have a fire. So I had to fill in my fire pit. I'm trying to, whatever, comply. I just feel like I'm being picked on. Plus I do recycling, for money.
Okay,
And I will
so,
do anything it takes. If I build a fence all the way across around my property, will that,
hold on, Mr. Norman, so
I'll
here's
do it
what I would
tomorrow.
like to know. In order to deal with the objection that was raised, do you know which of these photos was taken from the vacant property?
I can show you which ones. if
Could
you'd
you?
like. Yeah.
Could you?
every one of them? It's not vacant.
All right. All right. So y'all are in agreement. All the photos were taken from the vacant land.
It's not vacant.
I'm just going to, I guess, talk briefly to the county attorneys. I don't think these are legal. I think that you have to have permission to go onto someone's property to get the evidence in a code enforcement hearing. I know that on a postman's walk, photos you take on a postman's walk are valid up to a curtailage and so on. Do you have any reason to think I'm wrong in what I'm saying?
Respectfully, yes.
Okay, yeah, tell me.
So my understanding is that when you're looking at the due process and violations, it's their property. he did not access their property. Their rights were not violated. If a violation occurred, it would have been to the owners of the vacant lot, not to them. So if he had gone on their property, it would have been a violation. If he had put a drone up, it would have been a violation. If he'd gone off the curtilage, but all of that is on their property. He's not on their property, he takes this photograph. So any violation, if one did occur, would have been to the owner of the other
That
property.
makes
It would
sense.
not have been to them.
Yes, however, it's a, what's the phrase? Fruit of the poisonous tree issue. Is that the metaphor? Do you know what I'm talking about? Okay. I mean, I used to have to deal with it as a prosecutor at any rate.
In criminal language, yes, that is accurate,
Yeah.
but this is not a criminal proceeding.
No, it's
This
not a
is civil
criminal proceeding, but if it's, Go
With
ahead.
respect, she keeps referring to it as a vacant lot. It's part of their property, and we're friends with them. And I know he didn't have permission to go
Well, it
on
doesn't
the
matter,
property
I
too.
mean, to me, it doesn't matter if it's vacant or
You
not.
get
It's someone
shot
else's
if you go on
property.
some people's property. You know?
Is the county aware of any case law? I know there's, I mean, I
I wanna
have the
comply
case
with
law.
everything, you know, I mean, everything has
Sir,
to.
look, when I'm talking,
I'm
it will
sorry.
help.
I'm sorry.
That's okay. I'm gonna reserve ruling on that. The reason why I'm gonna reserve ruling is I don't need the photos to determine that there's a violation, okay, to be clear. And frankly, I think respondents have conceded that there was a violation. Mr. Norman, do you agree that there's been progress made on this case? Or are you aware of progress pursuant to your last inspection?
I believe that things have shifted around the yard at my inspections. I observe new junk and debris all the time, and this is not my first run-in with this property. I had this property before, and we worked together and we came into compliance, actual compliance. I had two cases. I had unlicensed inoperable vehicles as well as junk and debris. And I informed them that at that time that when I conduct inspections, majority of the time I will conduct my inspections from the roadway because that's just the easiest for me. But I also informed them that any violation that's observed from an adjacent property line can also be enforced as well. They were informed that the last time we spoke. They're starting to develop an extensive case history with code compliance. I'm just trying to ensure that we are utilizing our man hours to the best of our ability to make sure that this property comes into compliance and stays into compliance in order to prevent several trips out there because it's going to continue, and the complaints are going to continue until it's understood how he needs to store his debris on his property, which I've explained to him several times.
Okay. Like I said, I don't really need the photos to determine that a violation has occurred. Before I continue, I want to hear from the public, people who've come and waited. Would y'all like to come up and be heard? Okay. Then y'all can all come up, but one at a time, if you would, to the microphone. And you'll have to swear an oath and tell me what your thoughts are.
Do you swear to tell the truth?
I'm
the
sorry?
whole
Oh,
truth?
sure.
Oh. Thank you.
If they need, yeah.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
One at a time, can you state your names?
Candy Drake. I'm the neighbor, and number one, I gave Brandon permission to go on my property to take pictures.
It
I
doesn't
told-
appear that any of these photos were from
No.
that.
No, they probably behind me, Jeff, and it was okay with Jeff to have pictures taken.
Okay,
He couldn't be here today.
okay.
For about the last 3 years, he has harassed me. I had heart surgery. He tried to dig up my lemon tree. The neighbor came over and stopped him. He dug up a palm tree of mine, threw it on my front porch. I'd just come home from the hospital having heart surgery. I had a survey done on my property. I had a 6-foot vinyl fence put up. He took the survey sticks, threw them over the fence. I had to get a lock on my water faucet because he'd water his shrubs with my water and my hose. And he's just harassed me ever since. I'm a widow woman. I'm trying to live my life. I live by myself. I don't have any animals anymore, and I just can't handle this. I've got video here. I'll submit this to evidence of the night I had the deputies out. He had 2 strobe lights going in my bedroom
Well,
lights.
I can't, admit
I've
that.
had heart problems since this. This gave me seizures from the strobe lights in my bedroom light at 4 o'clock in the morning.
And so, first, let me just address the evidence real quick, you're not a party to it. If the county wanted to try and introduce it, they could, but I doubt it would be relevant for this specific case, if you will.
Well, I've complained about all the junk, because he leaves at 4 o'clock in the afternoon. He comes home in the middle of the night, every night with junk. And the junk just accumulates and accumulates and accumulates. It's terrible. It's like a junkyard.
All right, well, I want to get, is that all you have to say, ma'am?
Yes, sir.
All right, well, thank you. Who's next? And then at the end of this, you'll be able to respond. Sir?
One thing that hasn't been made clear yet is that he does all this work at 3 and 4 o'clock in the morning. And he has all these lights on. 3 or 4 days ago,
Your name, please?
oh, Mark Bailey.
Thank you.
Please proceed.
3 or 4 nights ago, he pulled his truck in the backyard, pointed it, he's got one of them big, real bright light bars on the top, pointed it right at my bedroom window. He bullies the neighborhood and intimidates people to not reporting. Last night, I was walking my dog. He squirts me and my dog with a hose, knowing he's coming in here today. He has no respect for you, me, or the law. He thinks he's above all that.
All right. Thank you, sir.
I mean, and the police have been called out there 9 times this year.
Thank you.
Oh, I did forget one thing.
Okay.
A few months back, it was on a Sunday, I was watching a football game, and there was this loud explosion, shook the windows in the house. I'm at least 1,000 feet away. And I go look out my back window, he's got a fire going 20 or 30 feet high. He had to put at least 5 or 10 gallons of gas on that fire for it to explode like that. And also, I'm a disabled veteran with PTSD, so noises all hours of the night cause me a lot of problems.
All right. Thank you, sir. Appreciate it.
Good morning.
Good morning.
My name is Becky Curtis. I live across the road, kind of adjacent. My address is 9185 East Winwood Loop. I have but one thing to say. The owner of the property states that he's disabled and he can't clean it off. He's the one that brought it in. Every piece back there, he's brought in. He lifted it, he dumped it, then what's the problem? He's the one bringing it in. There's loads continuously that he hauls in there. A lot of us in the neighborhood, we're afraid to be here today. We don't know what's going to happen. We don't know the repercussions that we're going to have. But some of us are stepping forward because something has to be done. It's hurting our neighborhood. It's scaring us to walk in the neighborhood. You walk by. I've walked by with Candy before, and he's been in his driveway, and he has profuse vanities at us, words that I won't even repeat in here because everybody's afraid. My only point is this: who brought the junk in? Did I bring it in? Did this lovely lady bring it in? No. So if he brought it in and he was able to do that, then why is he so disabled that he can't get rid of the junk? Candy knows this morning, I think she said at 3 o'clock, he was out there throwing junk in the back of a trailer.
Were y'all awake at 3, or did you hear it?
He wakes her up.
Okay. Okay.
Her bedroom is beside of their house. So she is probably the one that gets the most distraught over this. It is constant lights. It is constant noise, fires, just noise. And so she said this morning at 3 o'clock, she woke up. He was throwing things in the backyard. So my point is just this. If he just don't bring it in, then guess what? You don't have to clear it off. It has to stop, and it needs to stop. And the gentleman he took the pictures from, if anybody would look, call him, he doesn't care. Candy would have been more than happy to take him from her yard too. But we're just afraid. We're afraid of the repercussions from actually being here today. And isn't that a shame? Thank you.
Thank you, ma'am.
I have one more thing to say.
Okay.
Last week, he dropped a big, huge plate glass mirror. He came ripping around the corner, and this glass fell off on the road. and he just left it there. I ended up cleaning it up. And also, he obtained a boat from my neighbor across the street. He put it out at the street, said free, take the boat. He takes the boat, and he goes around the corner, and it's still there. Y'all can go see it today. Dumps the boat because it's fiberglass and it has no value as a metal. Because all he wanted was the trailer. And he went down, he just dumped it right in a retention pond. That's it.
All right, so, sir, the public does have a right to comment at these hearings, and I'll give you an opportunity to talk about what you heard, if you want to
All right.
respond. You don't have to, by the
Yeah,
way.
I'm gonna respond. These are all lies. She chopped down 4 of my fruit trees that were on my property, and I didn't do anything about it. She waited for us to go out of town, and I don't know who she hired. They left the stump there and tore up all my grass and stuff like that. And, I didn't do anything about that, so I got a degree in AutoCAD, so I looked at the blueprints, and I went out there and I measured it and did where the property line was. And her lime tree was on my property, a bunch of banana trees were on our property, and a sago palm. So I heard that she had a heart attack, so I gave her back her sago palm, just being nice. And I'm pretty sure I took some bushes from my neighbor, they got paid to remove them, and they're viburnums, and they're very, very vibrant, and they're healthy. They were just coming back with green leaves, because they were in shock for a bit. Pretty sure she poisoned them, or had somebody poison them, because every one of them went down the line are dead. Even the lime tree's dead now. And the ones that I moved to the other side of the property are fine. They've called and had said that there was a car fire, a brush fire. Like the other night, they called and said I threw something at her house. They instigate and yell at me, and I comment back, and they call the police on me. It's just crazy. I got home at 2 o'clock in the morning the other morning. Next thing I know, I was home 5 minutes. The police drive by, and they're flashing their lights. So I went out and asked him if there was any problem. He said there was a violation of the noise or whatever. He's like, no, I mean, just it's been lie after lie after lie after lie after lie. She even had cameras facing my house out. She has 3 windows on that side of the house. And you go out in the yard just to walk here to mow the grass, you can see the cameras. She's peeking. It's really creepy, man. But I don't say anything to these people. I mind my own business. And they're talking about bringing junk in. Yeah, I recycle, but it comes in, it goes out. You know what I mean? And if you look at those pictures, there's no junk really there at all. And all you see is tractors and.
Okay, all right.
I'm
well,
just really, really frustrated with these people. And I've lived here before they even got here, and they come into the community, they're trying to run things, trying to tell me what to do. And I don't.
No, you don't have, I'm sorry, it's just the
I don't
public has a
even know
right.
this guy,
and-
and he comes onto my property and tells the fire department that I put 20 gallons of gas on this fire. And I'm like, who are you? That's a fact. And what are you doing on my property?
Sir, I'm not, unfortunately, you don't have any more right. That's it.
And I've been very patient.
He has a
what I mean?
right to respond.
And they're pushing me and pushing me and pushing me. And I mean, what am I supposed to do? I mean, I'm in compliance now. I've got rid of everything. Got rid of the fire pit, everything. And I'm wondering if I can build a fence all the way around the backyard. Would that relieve everything of their complaints?
Does it, Mr.
What's
Norman?
in?
Hiding a violation does not abate the violation, sir.
Right, so if there's a bunch of junk and debris in the backyard, even if you have a fence, it's still junk and
We're
debris.
up on a hill, you can see right. But, I've already taken care of that. I built 2 carports, and they're about 30, 40 feet long. If I have any junk, it's gonna go directly into that carport. And it's
Well,
got 4 walls, and it's not gonna sit.
You've already
at all.
testified that it's all fixed, right?
Right.
So, I mean, my concern is how much time you would need to fix it. Apparently, you don't need any time.
Everything's done.
But if I gave you 7 days, let's say, just to absolutely make sure everything is to code, is that enough time?
Yeah, yes, sir. That's
Okay.
what I was doing last night, is I was getting
Well,
rid
what's
of
the county's
everything.
recommendation?
The Citrus County Code Compliance Division respectfully requests the special master assess a fine of $100 per day along with the administrative cost to begin after the date that you deem sufficient. To abate this violation, this amount was selected based on the actions of the property owners once they were advised of the violation, and this amount is appropriate given the severity of the violation as well as the respondent's actions to this violation. We would also ask The special master additionally find it's the respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection.
And so, I'm just looking something up real quick.
May I ask a question?
Yes.
The only thing that is in the backyard now that we have is the lawnmower that's to be used. It's covered with a tarp. And what is the other thing?
A little trailer.
And a little trailer that can pull the tractor.
And a
And it's
wheelbarrow.
covered with, and a wheelbarrow. Is that allowed to be in the backyard covered with a tarp? Or does
I don't
that
find
also
that a
have-
wheelbarrow is junk and debris. Is the lawnmower usable? Are y'all using the lawnmower?
Not right now, because it's off season.
But it's not unusable, correct?
No,
It's
every one of
used.
my
I'm not
mowers-
going to find that a lawnmower is junk or debris. What's the other one?
Do we have to have it covered?
No, I don't, I mean,
Okay.
is it the county's understanding that they have to be covered, a wheelbarrow and a lawnmower?
No.
Okay.
I think what she's referring to is, we had a phone conversation yesterday, and I informed her that simply covering the debris that's in the
Correct.
fire pit with a tarp, that doesn't
Okay.
abate the
Right.
violation. To me, that's an attempt to
All
hide
right.
it. And then,
And at the
That's
time,
right.
Yeah.
I was not sure what he was going to do, whether he was going to still try to fill it in, or whether he was going to try to dispose of it otherwise. And so that's why, and with the rain from
yeah.
last weekend, or mid-last week, it's not been able to even dry up to even consider burning.
if there was consistently tree debris in the fire pit, many times I've allowed folks to keep that stuff so that because you are allowed to burn tree debris. But if you look at the photos too, you'll also see that it's not just tree debris, it's also other junk and debris that is being put in the fire pit. I'm not sure if it's being burned or not. So based on my history with the property, I have to assume that under the tarp is not just tree debris, it's the junk and debris that was there prior to my inspection. And now it's just being covered.
Yeah, I mean, so what I'm gonna do is I am gonna find, well, what's the county's
Can I
recommendation?
speak? Sure.
Oh, what's the county's recommendation?
Can I speak?
We've already given it to you.
How much?
$100 per day.
Here's what I'm gonna do. You've got 7 days to make sure that everything is perfect, okay? That it's brought into compliance. And if it's not brought into compliance as ordered, a fine of $200 per day will be assessed. I'm going up based on public input, okay? So it's important to just make sure that it's done. And what I think part of the big narrative here is that this is going to be a deterrent to any other thing happening in the future, because if it happens in the future, there's not going to be a time period to bring it into compliance. It's gonna start instantly from the time that the violation occurs. Okay?
Can I speak one more time?
Yeah.
That one picture you was talking about, the wood and stuff like that, my neighbor Jeff on the other side, he was doing some construction, and he was throwing he's throwing stuff in my fire pit, from his backyard or whatever, and he didn't know about being able to burn wood, normal wood. That wasn't mine.
It's irrelevant to this
Okay,
case.
I was just letting you know.
Yeah, I appreciate it.
Thank you,
All
sir.
right, so that's it. Thank you.
Next cases on today's agenda, Valley Land LLC, case number.
Guys, I have to
I'm
take a
sorry.
5-minute break.
No
So,
problem.
I do want to get I want to get all these people out of here, of course, as soon as possible, but I have to take a 5-minute break. All right? Okay, I'm sorry. There you go. Okay, you guys are ready? All right.
Okay.
The time is 11:55 and we're back on the record.
Next two cases on the agenda. They're owned by the same person, but they're different property addresses. Do you want to do them together?
Yeah.
Okay. Valley Land LLC, case number 2023-00970, and case number 2023-01037, pages 33 and 34 of your agenda. Brandon Norman is the code officer, Joanna Coutu, the expert.
Okay. Good morning.
Sir,
Morning.
do you swear to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, I do.
And your name, please?
Arthur Neves.
Thank you.
And you're here on behalf of Valley Land LLC?
I am, yes.
Are you an owner?
As the owner, yes.
Okay, thank you.
Brandon Norman, Citrus County Code Compliance Officer. This is for case number 2023-0970 and 2023-01037. Both are for development applications applicability, violation of Chapter 4002 A, B, and C, or I'm sorry, Chapter 4, Section 4002 A, B, and C of the Citrus County Land Development Code. The address for a case ending in 970 is going to be 409 Spruce Street, Inverness, Florida 34452. The address for the case ending in 1037 is 413 Poppy Lane, Inverness, Florida 34452. Property owners for both are Valley Land LLC. I have good service via signed certified mail return receipts. And I would like to authenticate the following documents and request they be admitted into evidence. The photos will have different time and date stamps because they were received, complaints were received at different times. Exhibit A for case 970 will be photos taken during the initial inspection on October 4th, 2023, the corrective action inspection done December 18th, 2023, and the final inspection done yesterday, January 16th, 2024, as well as aerial images from the Citrus County Property Appraiser website from dated August 19th, 2023. Exhibit B for 970 will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the signed certified mail return receipt. Exhibit A for case ending in 1037 will be photos taken during the initial inspection on October 19th, 2023, the corrective action inspection done December 18th, 2023, and the final inspection done yesterday, January 16th, 2024, as well as an aerial image from the Citrus County Property Appraiser's website dated August 19th, 2023. And Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the signed certified mail return receipt.
Sir, I'd like to ask you to take a look at these documents and let me know if you have any objections to them.
Mm-hmm. Okay. Okay, I have no objection, Your
Okay,
Honor.
thank you, sir. You're not by chance conceding the violation, are you?
No,
Okay.
I'm not.
All right. And don't take the question to mean that I think you should. by the way. It's only asking based on time. All right. So without objection, what's been proposed as Exhibits A and B are evidence. Please proceed.
For the address at 409 Spruce Street, I conducted an initial inspection on October 4th, 2023, for a complaint of a site modification without permits to include tree removal. Property was found to be in violation that day for not having any permits issued. I sent a notice of violation to inform the property owner. It did change hands, so I had to resend a notice of violation. Once I obtained the correct information, we moved forward. I did hear from someone who identified themselves as the property owner. I don't remember.
It wasn't me.
It was.
Okay.
Yeah, I was about to say because that name
would
wasn't.
remember.
Yeah, that name wasn't familiar to me. And they stated they had no intentions to develop the property. I do want to notate too that for the case on 409 Spruce Street. For the tree removal, it actually ended up causing damage to a neighboring address, damaged a fence. So the complainant wanted me to make sure
The
that
certificate
I
of
expressed
service
that.
said it went to Valley Land LLC, care of Juliana Karfitsas.
So that's the new one that I sent. Once I started it, I had to start the case over once I was
Okay.
informed that it had changed ownership.
Gotcha.
So these are
Alright.
all the current NOVs and NOHs. For the case ending in 1037, I conducted an inspection on October 19th, 2023 for a report of site modification without permits to include tree removal. Property was found to be in violation, and I sent a notice of violation for not having any permits issued prior to the removal. If you look at the aerial photos too, you'll notice that both lots were clear cut. So there's absolutely no trees left on either property.
Well, who, to the county's understanding, actually did the clearing?
Regardless of if a contractor or someone was obtained to do the clearing, it's still the property owner's
I
responsibility.
mean, the prior property owner, you know. Okay, well, look, in chapter 19, violator shall mean the person creating or permitting the violation of any provision of the county codes, or a person who owns, controls, or is otherwise responsible for the real property upon which violation occurred. So, I mean, it gives a wide berth as to who a violator is here. And I understand that you've now got the current owner, but do you know who actually did the clearing in terms of who was the prior owner, who was responsible?
It's in my other records and log
Okay.
notes. I didn't think it would be pertinent for today. I apologize, but I can obtain that for you.
Is that the defense that you have?
No,
Okay.
sorry. I can answer that question.
Okay. Yeah, what-
we did it. We did a clearing. I
You
mean,
did
not
the clearing.
myself. Yeah, not myself. So there is no problem with that. Yeah.
Gotcha.
Yeah. So
So what is the issue?
yeah, can I make
Absolutely.
my statement? Okay. So just want to
And
definitely.
I don't know, Ms. Couture, do you want to say anything before we, okay.
Okay, so yeah, Arthur Navis, I'm the owner of Valley Land LLC. I just want to, first of all, appreciate your time and all your service, like the county and everybody here. I mean, bear with me, it's first time like
Yeah,
doing a
of
hearing.
course.
And I'm also first time like that I acquire some land and I want to invest and build houses there. So like you're probably going to see some of the mistakes I'm making and I'm learning here.
doubt
And
it.
I would love some guidance from the county and if
They're happy to
everybody
give
here.
it, yeah.
Yes. So the change of ownership, I'm not sure about that, but I can say that to answer your question, we were the ones that did the clearing. I ordered a clearing, I think October 2nd or something like that, the beginning of October, and it was done. It was, from my understanding, was that we had to do it prior to apply for permitting. We'll apply for a building permit. We actually are working with an architect and a GC. We have drafts, and actually, we're pretty close in the Poppy Lane. We should, hopefully, we're gonna be applying for a permit like within 2 weeks or in February. We have the draft plans. We're conducting the environment survey this week. And I believe that's what the county needs for us to open the building permit. If it's not, I would love some guidance there too. But yeah.
Sometimes it's best to check with them first.
I agree.
You know, I mean, and that's what this case is about, based
Mhm.
on what you're telling me.
I
It's-
agree.
Sounds like you're trying to do everything right, and indeed, that after the fact you are. But their issue is that you can't, and they have to set a precedent, by the way, you
Oh,
know?
uh-huh.
So we can't apply it unequally in different cases.
100%.
Yeah.
Yes. Yeah, so I think that's my statement. On the Poppy Lane, the plan there is, as I said, we already have the survey done, we already have the draft plans with the architect, their draft, we already have like the trusses, quotes and everything. We're doing the environment survey this week, so hopefully we're gonna put all that together and submit for opening the building permit. For the spruce one, the initial plan when we clear was to do them both at the same time, but as you can see, I'm still learning. So we changed plans a little bit to let's do Poppy Lane first, learn it, do it the right way, and then we can do the other one, and potentially in the future do more other, like to create more houses there. So I'm not 100% sure. I mean, I believe Poppy Lane, the next set of course here is like, we're gonna go ahead and open the building permit. Hopefully you're gonna give us some time to do that. And for Spruce, we're not gonna be opening the building permit like next week or next month. We will eventually, but let's say potentially in 6 months or.
Well, I suspect what the county, what is the county recommending in this case?
The Citrus County Code Compliance Division respectfully requests that the special master assess a one-time fine of $5,000 for each case, along with administrative costs to suffice these violations due to the irreversible, irreparable damage. We all know that you're supposed to allow a certain amount of trees based on the acreage, and now that can't be even talked about unless we go about replanting and just like Ms. Katu spoke earlier.
Yeah.
On the previous
Yeah, we need
case.
to think about how this replanting thing would work. But so what they're saying is there's no time to comply. You've done it. It's a completed action. And because the nature of the tree removal, maybe among other things, like some of the damage, it's irreversible. And it's not of the type that you get an opportunity. So I can't give a time to bring it into compliance. You can go get your permit whenever you want to get your permit. That's not up to me.
Right.
What I have to do is, it's really undisputed that there's a violation in each case, but you were here when I had a similar case, and I assessed a fine on for each of the lots. I'm inclined to do the same thing again. What do you have to say?
Okay, yeah, I think my point here is I believe the cases are a little bit different. The previous case, I don't know how much I can talk about the previous case, but the previous case was about keeping the vacant lot as vacant. And as far as I understood, if you want to open and build something on the lot, you can do the clearing. Maybe I could be misunderstanding what I just heard.
You can, but the damage that you've done, what they're saying is, even if you did a development, there's a certain amount of trees per acre, or there's an acreage requirement, there's a tree requirement.
Depending on the size of the lot, you're required to have a certain amount of trees. I would be more than happy to let Ms. Katu speak.
Yeah.
So basically, you can't clear cut regardless. Yeah, so that's the big thing is not only can't you do it before a building permit's in hand, you're not gonna be able to clear cut, which is what happened. You would have had to leave some trees
Understood.
regardless, so I
Okay.
think that's what.
What is the per tree acreage criteria?
It's in our land development code, you're a very small lots,
Yeah,
very
0.something,
small site,
yeah.
so there's a table in there for you. I don't have it memorized.
Okay, but like roughly what we're talking
No,
about?
no,
like-
no, 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 yeah. Well, actually, he has a right to cross-examine, so I mean,
He does, but I don't have it, it's in the code, but I don't know.
you don't know. So her testimony, she doesn't know, but it's in the code.
Sure, yeah, just trying to learn here as
No,
well.
that's
I'm
right.
sorry.
I mean, and so, I would help yourself to a printed copy.
I will get to that once I get home.
I mean, so that's the situation. Frankly, I respect the county's, fine request as well, and I know the county's doing what it needs to do to deter this kind of, but I'm inclined, based on the testimony, to reduce the fine substantially as well. So what I am gonna do is I'm gonna find is there anyone from the public who wants to be heard on this case? I don't see anybody, so I'm going to find that there is a violation on each property and assess a one-time fine of $2,000 on each lot. I know it'll get better from here, but that's the way it's gonna go.
Great. Thank you, sir.
Okay, thank you.
Next case on today's agenda, Jeffrey Scott Haynes and Freddie and Francis Gertman, case number 2023-01081, Code Officer Brandon Norman, page 16 of your agenda.
Good afternoon, now. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you, sir. Your name, please?
Jeff Haynes.
Thank you.
Good afternoon.
Good afternoon, Brandon Norman, Citrus County Code Compliance Officer. This is for case 2023-01081, an accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address listed is 10431 East Pintail Drive, Floral City, Florida, 34436. Property owners are listed as Haynes Jeffrey Scott, Gertman Francis W., and Gertman Freddie K. I have good service via signed certified mail return receipt, and I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on October 25th, 2023. A corrective action inspection done November 27th, 2023, and my final inspection done yesterday, January 16th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the signed certified mail return receipt.
So, sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them.
That's when we started. One is one for yesterday. Wheelbarrow. That's yesterday, so the only thing that's left there, I cleaned up all that. I don't know what that is. Oh, it's way back there in the back. Around that shed. Yeah.
Any legal objection to these documents?
No, I just didn't realize that you had to clean up stuff in the backyard too, where it ain't being seen, which I learned that here today. But the whole front yard is clean besides the trailer sitting in the front yard, and I'm allowed to have a trailer in my yard, ain't I?
Well, I mean, it depends. I mean, what I'll say is the code section doesn't distinguish between the front or the backyard. Like when you read the code section, it just says it's unlawful for the owner to permit, cause, or have thereon any accumulation of junk, debris, rubbish, vegetative matter, except for junk stored in enclosed litter receptacles or completely enclosed buildings. So I think that we could get into the trailer, but let's look at what you've got here. So, all right, without objection, what's proposed as Exhibits A and B are evidence, and I want to hear what the county has to say first.
Yes, sir. On October 25th, 2023, I conducted an initial inspection of the property for a complaint of junk and debris. The property was found to be in violation. The property remained in violation, and my notice of violation corrective action inspection completed November 27th, 2023, as well as my pre-hearing inspection that I conducted yesterday, January 16th, 2024. I have had contact with the property owner, and they are aware of the violation and how to come into compliance.
So they asked a question about the trailer, and I can see in the photo here that there appears to be a trailer with some stuff in it and a tarp. Is that junk?
That's a dresser that goes in the house.
Hold on, I'm asking Mr. Norman a question.
Since it's not an enclosed trailer, it would be considered junk and debris.
Okay, so it appears that you're
Not
making
the
an
trailer.
effort, you know, there's obvious improvement in the photos, but just putting something on a trailer in the front yard, covering it with a tarp, doesn't
Well, it was
satisfy.
going to rain, so that's why the tarp's over top of it.
Well, that's fine. I mean, but it's still a violation of the code section, which
it's
I
open and
read
exposed
to
to the
you, and it
elements.
says, you know, enclosed litter receptacles, like a garbage can that's enclosed, or a completely enclosed building. I mean, that's the issue. That's what you got. So that's what it's going to take. I mean, how much time would you need to fix the remaining issues on the property?
Well, can I say something?
Yeah.
For starters, he could have told me this a long time ago. I tried calling him and calling him and calling him, and he wouldn't answer my call. Finally, his boss got with me, and he told me the only thing I had left was the tin inside the house, and which is cleaned up, and the door leaning against the building. He said that's the only thing I had left to do. And we did that, and now he's saying I got to do all this other stuff.
I mean,
they got to tell me what I got to do, because I thought I had the yard compared to where it started. It looks really clean now.
It does. I mean, there's a huge improvement. But I don't think it's enough to just put a tarp on something. I mean, so you can blame me if you want, but.
What do you mean a tarp on something? I don't understand what you mean by that. Just by the trailer? I mean, trailer, they're gonna take me 2 seconds to pull it out of the yard.
Okay?
I don't
So
understand
that's what
what-
you would need to do, and so I'm asking you how much time you need to bring the property into compliance.
Well, I'm asking you or him, what else do I need to do to bring?
I've told you twice that the stuff under the tarp and on the trailer is a violation.
Okay, so.
What else is there that you're aware of?
From my inspection yesterday, I believe there's some debris in the back side of on the back right side of my
Okay.
photo that would need to be addressed. And
Right
then,
beside that little building?
which little building?
There's a little building there and it's right in front of it.
Are you talking on the left, if I'm
Well,
looking at the
if
property
you're
on the left
looking at
side?
it, be on the right.
Oh, I see it. I see the photo.
Yeah.
Yeah, there's
Yeah.
definitely some junk and debris there.
Substantial amount in that back portion
Yeah.
area. So if that can just be tidied up, that would abate that
So I'll
portion.
hold up its page,
Sorry, I wrote
exactly
small
what
on the
page it
bottom.
is, but you can look at it if you want, but.
Yes, I saw that, but I just didn't know you had to clean up the backyard too.
Right.
But that's fine, I'll have it done this week.
Well, and so I just want to give you a reasonable amount of time, and, I mean, is 14 days enough?
Yeah, that's fine.
Are you sure?
When's my surgery?
Oh, he has surgery on Monday.
Okay, I mean, so let's take that into account.
Yeah, so
And I'll be down for at least 3 weeks for that.
we at least have 30 days.
I can do 30 days. What's
Based on the
coun-
progress, 100%.
All right, that's fair. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative cost to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. And this amount is appropriate given the severity of the violation and the respondent's actions relative to these violations. We would also ask that the special master find it is respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection.
What was the dollar amount?
$50.
Yeah. All right, so what I'm gonna do is I'll find a violation, but due to the improvement that's already occurred, we'll give 30 days to complete this, get it all fixed, and if it's not brought into compliance as ordered, a fine of $50 per day.
Okay, can I ask you one more question?
Sure.
Or maybe you, what's the other names on that property? Because that's my property.
Well, so here's what I'll say is, actually, at these hearings, all comments are supposed to be directed to me.
Oh, I'm sorry.
I will say that there are other names on here, but it's not relevant, frankly, for this hearing, and so I'd ask that y'all handle it. We've got a lot of people waiting.
Oh, I
so-
understand.
All right,
But I
thanks.
just didn't know they was on there. That's why I
Yep,
was asking.
fair enough, thanks.
Next case, Richard Tate, case number 2023-01082. Code Officer Julie Wilkinson, page 31 of your agenda. Expert witness on the case, Land Development Director Joanna Coutu.
Sir? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your name, please?
Richard Tate.
Thank you.
Good afternoon.
Julie Wilkinson, Citrus County Code Compliance Officer. This is case number 2301082. Special requirements for all accessory uses, a violation of Citrus County Land Development Code 3102A. The address is 6279 South Pleasant Avenue in Homosassa. Property owner is Richard Tate. Have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on October 25th, 2023. Photos taken during a corrective action inspection on November 16th, 2023. And photos of my final inspection conducted on January 16th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a copy of the notice of hearing posted on the property, and a copy of the posting affidavit. Exhibit C, a copy of the continuance letter, a copy of the continuance letter posted on the property, and a copy of the posting affidavit.
So, sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence.
Yeah, well, this is, I guess it's some before and after. I'm trying to differentiate where the pictures go from before and after, but yeah, this is correct, sir.
Okay. And that's fair. So I don't hear any objections to their authenticity or anything like that.
No, sir. Like I said, some of them are the original pictures and some of them are like today.
They all have dates on them.
Okay, well, I don't feel like I have any objections to any of that.
Okay. All right. Thank you. Okay. Then without objection, what's been proposed as exhibits A and B are evidence, and please proceed. Unless you can't. Is there something wrong?
I just need the hand sanitizer.
Oh,
Need the
okay.
hand sanitizer, please. Thank you. Oh, yeah, my bad. On October 25th, 2023, I conducted an initial inspection and observed an unpermitted mobile home, multiple sheds, construction material, furniture, appliances, chickens, wood pallets, clothing, miscellaneous junk and debris on the property. On October 30th, 2023, a notice of violation was issued for special requirements for accessory uses, which is a violation of the Land Development Code. On November 16th, 2023, a corrective action inspection was conducted with no change to the property. I have had contact with Mr. Tate. He has called the office numerous times to ask for leniency and for exception of the code to be applied to him. He's also expressed that he feels he's being harassed. Mr. Tate had requested and was granted a continuance. As of my final inspection on January 16th, 2024, the property remains in violation. Mr. Tate has had the sheds and the mobile home removed from the property, but nothing else is there. Or nothing else there has been removed.
Okay. Mr. Tate, it does appear that there's still some stuff on the property, and so do you understand what the county's case is?
Well, I've got it says to, well, the livestock animals, that was the first thing I did.
Yep.
And accessory uses or structures, I did in fact have a small mobile home, and there were 3 sheds on the property, and they're all gone now.
Right.
And I was in fact living in one of the sheds. I am no longer doing that. And I was hoping to get abated because those items.
You're pretty close, based on what I see, but there is still stuff on the property, and so,
well,
actually, and this might help, I would like to ask Ms. Katuta if she would testify. I can't compel it, but I think you're ready to.
I think you can, but that's okay. Joanna Coutu Land Development's about 4.7 acres, rural residential, mobile homes allowed. There are no permits or any kind of development approved here. It should be vacant.
Okay, so what she's saying is the issue here is it actually has to be vacant. You can't be doing anything on the property unless you have a permit on the principal stuff, or you've started getting the principal stuff underway, and you haven't. Does that make sense? You have to build a home. I mean, is that right? Is this a residential? So you've got to have a home on that property.
Well, I mean, do you consider the mobile home and the little mobile home and the 3 sheds and not living there, and the chickens, and I had to get rid of my chickens and everything? Do you consider that significant?
If you're storing boxes there, that's an accessory use. It's storage, and you can't do it unless you have the principal use established.
In an earlier case, you said some things you consider junk and debris, some things you do not.
It doesn't matter whether it's junk or debris. If it's anything at all on the property, when you don't have the principal use established, you can't do it. You can't store things there unless you have the principal use. You can't. I don't think you can even put a park bench there. I don't know if you can put flagpole. I think you could put a fence. I don't know. I think you can put, well, okay. But either.
Can you put a fence?
I don't know. I thought you could, but, yeah, I think you can put a fence to secure it, but you can't establish any accessory use on the property.
And there isn't at this time.
There's stuff on there. I see stuff in the photos. As of yesterday, there's still stuff on the property. That's an accessory use. You're storing stuff.
Okay, well, I'm gonna lose. Just tell me what I have to, what do I need to, what's going on here?
You have to abate the violation one of two ways. Either you need to remove everything that you've got on the property, or you need to establish a principal use on the property. You need to build a house, essentially. So it's one of the two, one or the other.
The chicken coops, the chickens are gone, but the chicken
Yep.
coops are still there, and you're saying they have to be.
Correct.
Because I mean, look how big I am. I can't access it. I can't access that.
You can't what?
Well, it
Accessory?
says accessory structures, and I can't go in it.
Accessory just means that it's on the side. It's not a principal. Accessory just means not the principal. So the point is, it's on the property. It's not allowed to be there without the principal use, period. And I can give you an amount of time that you need to bring the property into compliance.
Okay, yes, sir.
How much time do you need?
Well, I don't want to just set fire to everything there, because that doesn't do anybody, it doesn't do the environment any good, it doesn't do the neighbors any good, it doesn't do me any good. Some of that can be used to make some, the wood there, which is a lot of wood, can be used to make something out of. And I mean, I feel like I could get it all done in 6 months. I am by myself, but however, I have been blessed to have a good running truck, so I could probably do it all in 6 months, and, because I have no plan right now in place to get rid of the chicken coops, whether it be bless somebody with those, or try to get a little bit of money out of them, or give them to a fellow farmer or something or other,
What is there anyone from the public who wants to be heard on this case? Okay. Let me just take another look at the photos. I'm just trying to assess the magnitude of what still needs to be done.
I built those, I mean, they don't look like much, but they worked.
Yep.
For what they were designed to do.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day, along with the administrative costs, begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally to find that it is respondent's responsibility to contact Code Compliance Division when the violation has been abated in order to allow for reinspection.
And I think I heard this is 4.7 acres. Okay. Well, Mr. Tate, I don't know. I think you can probably get it done faster, but I don't see any reason not to grant your request. So I'm going to say the property's in violation, give you 6 months. And if it's not brought into compliance as ordered, was it a fine of $100 per day?
Yes, sir.
$100 per day. And I wish you luck.
Thank you.
Okay.
Okay, will there be will I get an email or something?
You'll get an order.
In the mail, sir?
Yes, I think it's by mail.
Okay, y'all want me out of here? I'm out of here now?
Yes, sir.
You can go.
Next case on today's agenda, Jamie P. and Krista J. Dwyer, case numbers 2023-01101 and 2023-01216. Code Officer Amy Becker, pages 10 and 12 of your agenda. Excuse me, 10 and 11 of your agenda.
Okay. Good morning.
Good afternoon.
Oh, I'm sorry. Good afternoon. Yep, got me.
Good afternoon.
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. State your names for the record, please.
Jamie Dwyer.
Thank you.
Amy Becker, Citrus County Code Compliance Officer. This is case number 23-1101, abandoned, unserviceable, and unlicensed vehicles, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 4, Section 20-41. And case number 23-1216, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address is 10292 North Allwood Terrace, Citrus Springs, Florida. The property owner is Jamie P. Dwyer and Christina J. Dwyer. I have good service via posting of the property as well as the Lecanto Government Complex. I would like to authenticate the following documents and request that they be admitted into evidence for both cases. Exhibit A, photos taken during my initial inspection on October 31st, 2023. Photos taken on November 9th, 2023. Photos taken on December 5th, 2023 at my corrective action inspection. Photos taken on January 5th, 2024, showing the posting of the property, and photos taken on my final inspection, January 12th, 2024. Exhibit B, a copy of the notice of violations, a copy of the notice of hearings and pre-hearings order, and a copy of the posting affidavit.
So I'd like to ask you to take a look at these documents and let me know if you have any objections to them being evidence in this hearing.
No objections.
Okay, thank you. Okay. Okay, thank you. And again, I'm just curious, are you contesting the case? Either of the cases?
I'm contesting certain claims of the case.
Okay, then please proceed.
On October 31st of 2023, I conducted my initial inspection for abandoned, unserviceable, and unlicensed vehicles and observed inoperable vehicle in the driveway and an SUV in the backyard. And as far as the junkyard conditions, I observed auto parts and other debris. As of my final inspection on January 12th, there's been major progress made. The cars, untagged vehicles have been removed except for the SUV in the back, and the majority of the debris has been removed.
All right, let me just check these out. Exhibits A and B are admitted in each case. Let's talk about the unlicensed vehicle case first.
Please.
So what's going on there?
The SUV in the backyard is licensed and insured, and it's operable.
And it's operable.
So I can't be faulted for people's poor taste in vehicles. They don't like my flat black mud truck.
It's the black Suburban?
Yes, sir, at Tahoe.
Tahoe.
It is licensed, insured, and operable.
Now, as of January 12th, I mean, I don't see a plate on it.
It's a side shot of the truck. The rear of the plate is facing my property. My building. The truck is backed into my building.
I see. When did you get it tagged?
Well, I just recently re-tagged it,
Mhm.
Previous to her pictures. But, I mean, it's always been an operable vehicle.
So
I
you're
took it-
saying it's never been,
It's not a junk vehicle. It's always been, it's a vehicle that we don't use because we have a lot of vehicles, obviously.
do you have a copy of the registration or anything?
Right here.
Could you show it to Ms. Becker? Would you mind? I mean, what do you
That's the only vehicle on the property that is of question because she couldn't see the plate.
Have y'all
It
been in
does run,
touch,
we can't
have y'all
use it.
been in touch with Ms. Becker during this case?
No, only the time she came out, that, I think she spoke to my wife.
Okay. I mean, did y'all explain to her that the car was registered and operable?
I don't know that she, I don't know.
The last time that she was by, it was not registered and insured.
Okay,
And
that's,
it has been since then.
I see,
Yes.
okay.
It's always
Is
been
it?
operable.
I mean, what is that?
Yes.
Okay, okay.
It's always been
All right.
operable, it's just not, we just.
Then I'm gonna, then do you want me to let that case go?
Well, I mean, I need to get a copy of that, so I would need a copy of that in order to put it in the file, but I'm fine with that.
Yeah.
Okay. We do,
So I guess.
No,
You have the
I
copy.
take Ms. Becker's word for it.
Whoever reads the
And
copy.
I think y'all have, I mean, y'all conceded that it wasn't in compliance in the beginning.
Right, no,
Now
no,
it
it-
is, so that's fine.
Well, see, I have contention with that. It's always run, it's just an ugly truck. I took the tag off, my kid needed the tag.
So, I mean, well, just because something runs.
Come on now, it's not junk.
Well, wait, now, hold on. So just because something runs doesn't mean it's operable. It has to be operable as a vehicle.
Oh, I got you, okay. All right, I'll give you that one. It
Well,
operates.
what do you mean?
It's operable. I could get in it and drive it anywhere.
Okay, do you feel comfortable driving it?
Absolutely.
Okay. I mean, this case isn't predicated upon the quality of the engine. It's predicated based on the lack of registration, correct?
Correct. He's telling me I have to take him at his word, and they've both been very honest with me. He's telling me that it works, and it's now
The
tagged.
tires look
So-
like they're inflated. I just don't have any evidence otherwise. So, all right, I'm gonna let go of the unlicensed vehicle case. But let's talk about I mean, I don't know, I don't actually see the improvement. I know, you've told me there's improvement, I
Well-
just don't see it.
I saw improvement.
Go, as of yesterday, there's nothing on the side yard at all.
I mean,
The only thing.
well,
that's on
so the photos I have are from the 12th, I
12th.
believe, yeah. So I guess there's been improvement since then, but pretty rough.
Sir, there's nothing on my side yard. If you took a picture as of this morning.
Okay.
That's of the 12th. Can I see the pictures of the 12th?
Yeah, let me show you just so we can make sure we're on the same page.
Yeah, I want to make sure, because actually, you know what? That was a weekday, so that was the weekend he came. Right. So I could see that the topper would still be there and.
Okay. So,
Oh, yeah,
this is the
that's-
12th.
yeah, that's all.
And then, well, let me just ask you a question now that,
Yeah.
so we
Sure,
make
sure.
sure that we're in compliance. So are the car parts still here?
No, that's all gone.
Okay, and then, that's great. And then as far as the back, is this pile of wood?
I think the wood might still be there.
Has to be taken to the.
We did
Okay, and
break
then
it
there's
down.
a chair over here that,
I don't know if that's still there. Is that still there?
so we've got the wood, we've got the chair, and then, there's an appliance.
That's gone. That's
Okay,
all
so
gone.
they're close.
Okay, yeah, I
They're
believe
close,
that.
very
So
close.
the
No,
only
we got
question then is, how much time do you need to get everything done?
What? I got a week? I
Two-
gotta pull a
two
pile
weeks?
of wood?
Well, does 2 weeks
Is
work?
it, all the complaint is the wood, right?
It's the chair, the appliance, the
Well,
wood.
the chair's a lawn chair.
But it's in disrepair. Do you want, I mean.
No, that's okay.
it's
I
not
don't care.
usable.
That's fine.
So that's something that can't be used.
So I'm not gonna argue over a chair. So the chair and the wood.
And the appliance, there's an AC.
No, that's
there's-
gone, that's all gone.
Okay,
Okay,
but
so-
I just need a number. How much time do y'all need to get everything done? I'll give 2 weeks.
5 o'clock.
Okay, so what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine for both cases, 23-1216 and 23-1101, of $50 per day for each
Yeah,
I'm gonna close
Yeah.
the vehicle. So
Yeah.
it'll be just for case 23-1216, $50 a day, along with administrative costs, begin after the date you deem sufficient to abate this violation. This amount is appropriate under severity of the violation and the respondent's actions relevant to this violation. And we'd also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
okay, 14 days to bring it into compliance and $50 a day if it's not. So, thank you.
Thanks.
Next case, Doris L. Hutchinson, case number 2023-00450, Code Officer Julie Wilkinson, page 17 of your agenda.
Good afternoon.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And your name, please.
Doris Hutchinson.
Thank you.
Julie Wilkinson, Citrus County Code Compliance Officer, case number 2300450, accumulation of junk and debris, in violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 6480 West Holiday Street, Homosassa, Florida. Property owner is Doris L. Hutchinson, and have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on July 14th, 2023, a corrective action inspection on November 7th, 2023, and photos from a final inspection conducted on January 16th, 2024. Exhibit B, a copy of notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a copy of the signed certified mail return receipt. Exhibit C, a copy of the continuation letter, and a copy of the signed certified mail return receipt.
All right, ma'am, I'd like to ask you to take a look at these documents and let me know if you have any objection to them.
My grass is pretty. Oh, stupid. No, I have no objection.
Okay, thank you. Okay, without objection, what's been proposed as exhibits A and B are evidence.
This case was continued from December 20th, 2023. A special master hearing. On July 14th, 2023, I conducted initial inspection and observed construction material, auto parts, garbage, miscellaneous junk and debris on the property. On July 17th, a notice of violation was issued for accumulation of junk and debris, which is a violation of the Citrus County Code of Ordinances. On August 3rd, 2023, I conducted an inspection and found that no progress had been made. However, while at the property, I spoke with the property owner who stated she was sick with COVID, and that's why nothing had been done. I gave her additional time to come into compliance. On September 5th, 2023, I conducted an inspection and found little change to the property, but due to Hurricane Idalia, I gave her additional time. On October 6th, 2023, I conducted an inspection and found some progress and gave additional time. On November 7th, 2023, I conducted a corrective action inspection and observed that the property remained in violation with progress towards abatement stopped. As of my final inspection on January 4th, 2024, a property remains in violation, and now there are fences being put up which partially obstruct the view to the backyard. That's it.
Okay, all right, so ma'am, what's going on?
Okay, so I don't deny that there's a fence there, and I told him not to put it there. Not only is it heinously ugly, it's illegal. I know that the property's in violation. I let ex-boyfriends store things, and we fought hard about it. I didn't want any of it there. The reason why it's taken me so long, Ms. Julie, is because I had to save money to pay someone, and I paid $3,000 to have 13 tons of his junk removed, and I'm still working on it. I'm doing my best. I did take a couple loads to the dump myself, but I couldn't. There are no unlicensed vehicles. There's no more RV. There's no more boats. All that stuff is gone. I've got a pile of tires, and he does have some scrap metal that he needs to either put in the shed or take it away. I want him to take it away.
Well, it's on your property.
I know.
And so the issue is, it's just really comes down to a number. And the number is how much time do you need to get this done?
At least a month, so that I can save money to pay somebody to take it if he doesn't take it.
Okay.
But I know that I've had a long time. I know. I really do. And y'all saved the best for last. I'll sit here all day. And the reason was continued last time was because I had COVID again. I've had it a lot because I work in healthcare. So it's something I deal with. But I'm trying my best.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask that the special master additionally define that it's respondent's responsibility to contact Code Compliance Division when the violation has been abated in order to allow for reinspection.
Okay. Ma'am, I do find that the property's in violation. I'll give you 2 months to bring it into compliance. If it's not brought into compliance, it'll be a fine of $100 a day.
Thank you so much.
Good luck.
Thank you.
Thank
Will
you.
I get another date to come back here?
No.
No,
I hope-
I just call her.
I mean, no offense, but I hope you won't be coming.
No,
back.
I don't want to. But
yeah,
I'll just
so-
call you when it's all done, right?
Yes.
Okay.
Okay, thank you.
Thank you so much.
Next case on today's agenda, Thomas and Melissa Crespo, case number 2023-01185. Code Officer Cody McGuire, page 7 of your agenda. Expert on the case, Joanna Coutu. Agenda.
And I'm sorry, what page?
7.
7, okay.
Yes, sir.
Okay, so we begin the march.
Yes.
Yep. Please proceed if you can.
Okay. Cody McGuire, Citrus County Code Compliance Officer. Case number CE 2023-01185, a violation of Citrus County Land Development Code Section 4002, site development without a development order or permit. Address is 12362 West Riverwood Drive, Christopher, Florida. Property owner is Thomas and Melissa Crespo. Good service via signed certified mail return receipt, and we're posting at the Lecanto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A is photos I took during my initial inspection on November 16th and aerial photos from the Property Appraiser's Office website. And Exhibit B, a copy of the notice of violation, notice of hearing, copy of the signed certified mail return receipt, and a pre-hearing order.
Okay. Is there anyone from the public who wants to be heard on this case? Nope. And Exhibits A and B will be introduced without objection. Just for the record, I won't be asking for public input anymore because I don't see anyone from the public. That'll change if someone shows up. All right, please proceed.
Okay. I conducted my initial inspection on November 16, 2023, and observed the property had all trees removed. While researching the property, I observed that there were no permits applied for or issued, and the aerial photos from the property appraiser's summary depicts a large amount of tree cover on the property before trees were removed. I have had contact with the property owner, Melissa Crespo, on December 11th, who stated they had purchased the property for a retirement home. She then came into the office the same day and spoke to Lori about not knowing the ordinance. As of my final inspection on January 16th, a permit has not been applied for.
Okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assesses a fine of $5,000 along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violations. We'd also ask the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Did you talk to them about paying a fine, or do you need an order from me before you can take money from them?
I don't take money from
In
anyone.
other words, I'm curious, like, did you have to bring the case, or did you talk to them? No, does it make sense? I don't know.
Oh.
Yeah, okay.
Yeah, that wasn't discussed.
Okay, I just don't, I mean, is it something you can do? Or, okay,
No.
interesting. I don't, I guess I think you're right. Okay. Okay, well, in this case, I am gonna find a violation, and I will assess the recommended fine of $5,000. I don't have any other mitigating evidence, so, thanks.
Thank you.
Let's see. Next case on the day's agenda, Sherry L. Runn and Sherry L. and Christopher A. Runn. Case number 2023 01225, Code Officer Brandon Norman.
Good afternoon, Brandon Norman, Citrus County Code Compliance Officer. This is for case 2023-01225, fences, hedges, and walls, a violation of section 3150 of the Citrus County Land Development Code. The address listed is 13059 East Shawnee Trail, Inverness, Florida 34450. Property owner listed as Sherry L. and Christopher A. Rund. I have good service via posting at the property. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on November 21st, 2023, and the corrective action inspection done on December 14th, 2023, and the final inspection done yesterday, January 16th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and then a affidavit of posting at the property, as well as a photo of the posted notice at the property.
Without objection, what's been proposed as exhibits A and B are evidence. Thank you.
On November 21st, 2023, a compliance inspection was conducted for a different case involving junk and debris. That's when I observed the makeshift fence had been erected using plastic sheeting and tree debris to hide the junk. I issued a notice of violation for the fence, and the property remained in violation of my corrective action inspection on December 14th, 2023. As of yesterday at my pre-hearing inspection on January 16th, 2024, the property remains in violation. I have had contact with the property owner. They are aware. They have no intention of removing it.
They don't care?
They don't care.
I mean, what did they tell you exactly?
They tell me to kick rocks.
Really?
And so many.
Yeah.
Not
I mean,
out
that's
there.
interesting.
Not
Okay.
out there. They need a pound sand. It's a rough road on Shawnee.
Have you had prior cases with these?
Yeah, you've made rulings.
I was
on
going to
them.
say, I
Yeah.
recognize.
RV occupancy, unlicensed inoperable vehicles, as well as junk and debris.
Okay.
So,
Ms. Katu, do you have anything you want to offer?
Not really, you got the background.
but yeah, they're using tree debris and stuff to stick
Ms.
inside
Katu, have
the-
you ever interacted with these folks?
No.
Okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day along with administrative costs for each, to abate this violation, to begin after the date that you deem sufficient. This amount was selected based on the actions of the property owners once they were advised of the violation, and this amount is appropriate given the severity of the violation as well as their respondents' actions relative to this violation. We would also ask the special master make it the respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection.
How much time did you give them after you began your investigation, like to bring it into compliance? Before you called it up?
Yeah, so I initially gave them approximately like 2 weeks. I even extended that for a little bit because when I did speak to the son, I mean, the son has always been polite with me. It's the people occupying the RV who are the people who don't care too much for me. So, and they're just refusing to come into compliance.
All right, the property's in violation. I'll grant a month to bring it into compliance. If it's not brought into compliance, $300 a day will be the fine.
Thank you, sir.
Thanks.
Next case, Kerwa, Michigan LLC, case number 2023-01160, Code Officer Brandon Norman, page 19 of your agenda, Land Development Director Joanna Katu.
Brandon Norman, Citrus County Code Compliance Officer. This is for case 2023-01160, Special Requirements for All Accessory Structures, violation of Citrus County Land Development Code, Section 3102A. The address is 510 South Little John Avenue in Inverness, Florida, 34450. Property owner listed as Kerwa, Michigan LLC. I have good service via posting at the property as well as looking into a government building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on November 7th, 2023, my corrective action inspection on December 21st, 2023, and my final inspection done January 16th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the posting affidavit, as well as a photo of the posted notice of hearing.
I think the exhibits are admitted without objection. And I think I get it. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation, and this amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master to find its responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection. I do want to state too that Ms. Joanna Coutu has a statement as far as permitting.
Okay, sure.
Just to let you know, they do have a building permit application in. They submitted that in October. It's been sitting since December 28th, waiting for subcontractors to sign off. Once we get that, we can issue it, but it's been sitting there with no response.
That's interesting, okay.
They are aware of it as well. I think this is the second time they've went through the application process. They let it lapse one point, so.
So can they abate it by just pulling the permit or getting the subs to sign off? And then they get to keep the materials there?
The permit would allow the materials to be there for the construction of the principal structure.
And that's really, I mean, that's all I see.
That's the majority of the problem there is. Okay. But again, I've been in contact with him. He knows what's holding up the process right now. He tells me that he's working on it, but we've seen no progress.
All right, well then, I'll find the property in violation, give 30 days, and if it's not brought into compliance in 30 days, it'll be $50 a day fine.
Thank you.
Okay, thanks.
Next case, Marion Delayed, case number 2023-01200, Code Officer Julie Wilkinson, page 9 of your agenda.
Julie Wilkinson, Citrus County Co-Compliance Officer. Case number 23-01200, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 5470 South Boulevard Drive, Homosassa, Florida. Property owner is Marion Delayed. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on November 20th, 2023. Corrective action inspection on November 7th, 2023. Photos of my final inspection conducted on January 16th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, copy of the general pre-hearing order, a copy of the notice of hearing post on the property, and a copy of the posting affidavit.
All right. The exhibits are admitted without objection. Thank you. I do think that the evidence speaks for itself. I think there's a sufficient factual basis based on the photos. Did you take these photos?
Yes, I took these photos.
Okay. I mean, I see that junkyard conditions exist. What's the county's recommendation?
$100 a day along with the administrative costs to begin after the date you deem sufficient to abate this violation. We'd also ask that you find it's a responsibility to contact Co-Compliance Division once the violation has been abated in order to allow for reinspection.
I'll do so and find that the property is in violation, grant 30 days to abate the violation. If it's not brought into compliance as ordered, $100 per day.
Thank you.
Thanks.
Next two cases on the agenda, Robin L. Fenner, case numbers 2023-1169 and 2023-1168. Property 2600 North Bucknell Terrace in Hernando. Code Officer Alan Jonason. I just got so used to saying that. Pages 12 and 13 of your agenda.
Alan Jonason, Citrus County Code Compliance Officer. I have two cases. Case number 2023-01168, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. And case number 2023-01169, unlicensed inoperable vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. Address of the violations, 2600 North Bucknell Terrace, Hernando, Florida. Property owner is Fenner Robin L. I have good service via posting the notice of hearing on the property and posting at the LaCanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 13 November 2023, photos from my compliance inspection on 21 December 2023, and photos from my final inspection conducted on 16 January 2024. Exhibit B, a copy of the notices of violation, a copy of the notices of hearing, a copy of the posting affidavits, photos of the notices of hearing posted on the property, and a copy of the pre-hearing order.
Okay. No, she doesn't want them. Without objection. Oh, okay. Perfect. Without objection, what's proposed as exhibits A and B are admitted as evidence in each case. I'll say that, usually on the junkyard conditions one, I can see it from the photos. Though, let's see. I have.
It's pretty clear.
Oh, I see. So wait, you divided.
Yeah,
I see what you
they're
did.
one exhibit, but I divided them so you would know what the violations were.
Gotcha. So
Yes, sir.
just for the record, pages 14 through 16 of Exhibit A pertain to the unlicensed vehicle. We'll have that be Exhibit A in that case, and pages 1 through 13 will be Exhibit A in the junkyard conditions case. And I do agree about the junkyard conditions, looking through the, have you had any contact with the owner?
I have not.
Okay. On the unlicensed, sometimes it's hard to tell from the photos about an unlicensed vehicle. What's going on there?
So there's a red Pontiac Fiero sitting on the side of the yard
Yeah.
back there, has no visible registration, appears inoperable.
There's no tag on it?
No, sir.
Oh. It's hard for me, from the photos.
It's kind of shiny, but there's no tag
There's no
on there.
tag on it?
No, sir.
Okay. You're not just assuming that a red Fiero is unlicensed?
Now, I would love to
and
talk to
inoperable.
the person about
Yeah, that's
getting
right.
this Fiero
Yeah,
for myself.
I like
because
those old
they're such a
Fieros.
great sports car, but
When in the 80s, I was, like, when my neighbor got one, I was like, wow.
I wanted one. When
Yeah,
I was
of
young.
course.
Everybody did.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests the special master assess a fine of $100 per day per violation, along with the administrative cost to begin after the date you deem sufficient to abate the violations. This amount is appropriate given the severity of the violations and the respondent's actions relative to the violations. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violations have been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. In each case, I'll grant 30 days to abate the violation, and if it's not brought into compliance as ordered, $100 per day will be assessed.
That's per violation, correct?
Correct.
Thank you.
Next case, Charles Nelson Marshall II, case number 2023-1024, Code Officer Brandon Norman, page 21 of your agenda.
Brandon Norman, Citrus County Code Compliance Officer. This is for case 2023-01024. Special requirements for all accessory structures, a violation of Citrus County Land Development Code, Section 3102A. The address is 223 North Hebrides Point, Inverness, Florida, 34450. Property owner is Charles Nelson Marshall II. I have good service via signed certified mail return receipt, and I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on October 13th, 2023. The corrective action inspection conducted on December 18th, 2023, and the final inspection done January 16th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt.
Exhibits A and B are admitted into evidence.
It's a vacant parcel with a shed on it.
On the agenda, it's shown as a 20-31 violation, but the notice is correct, and I don't, yeah,
I apologize.
that's okay. Although that would explain why Ms. Katu was listed as an expert, because I was wondering why she would be here on a junk case, so. All right, let's see.
It may not have ever been changed in the system, because I think the original complaint did come in as junk and debris,
I see.
so I apologize for that.
Yeah, it's okay. So it's residentially zoned.
Mm-hmm.
Nothing on it except for this
That's
shed.
it, just
Okay.
that shed right there in the back.
What's the county's
corner.
recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with administrative costs to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master find its respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection. The only reason why the increase in fine is because they obviously signed the notice.
That's what I was wondering. How much did you recommend?
$100 per day.
Yeah.
And they've made no attempts to contact me.
Yeah, and I was also wondering about the timing on it. I mean, it was signed on, I guess, the 8th.
But I have good service for the notice of violation as well.
No, I
just don't
know.
include it.
I'm wondering about the amount of time. So I adopt the county's proposed findings of fact. I'll grant 45 days from today to abate the violation if it's not brought into compliance as ordered, a fine of $100 per day.
Thank you.
Next, 3 cases on the agenda. Edward C. Schumacher, case numbers 2023-1243, 2023-1288, and 2023-1289. Code Officer Amy Becker, pages 26, 27, and 28 of your agenda.
I was hoping we wouldn't go a whole hearing without an overgrown grass case. And you did not Yeah, that's right. And you didn't disappoint. So here we go.
Okay. Case number 23-1243, excessive growth and accumulation of vegetation, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 6, Section 20-61. Case number 23-1288, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. Case number 23-1289, abandoned, unserviceable, and unlicensed vehicles, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 4, Section 20-41. The address for all 3 is 8884 North Limbo Circle, Citrus Springs, Florida. The property owner is Edward C. Schumacher. I have good service via posting of the property and a signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on December 5th, 2023. Photos taken on December 21st, 2023 at my corrective action inspection. Photos taken on January 2nd, 2024, showing the posting of the property. And photos taken on my final inspection, January 12th, 2024. Exhibit B, a copy of the notice of violations, a copy of the notice of hearings and pre-hearing orders, a copy of the posting affidavits, and the certified mail return receipt, signed for on January 2nd, 2024.
Okay. What's, all right. Yep. All right. Okay, and it's A and B in each, right?
Yes.
Okay. Okay, exhibits A and B in all 3 cases are admitted as evidence. And I think I can save a little bit of time probably. Is there a reason why this ruler was here waiting for me? Y'all expecting me to use it?
I left it there by mistake.
Okay, no, I was like, are you sending me a message? Like, you don't measure up? Or, okay, let's look at the unkempt lawn. This is, let's see. Yeah, I mean, I certainly see it on the overgrown, unkempt lawn case. Have you had contact with the owner?
No, and it's frustrating because I have his phone number, or, excuse me, I had previous cases on this before, many moons ago, and he will not answer his door. There was a truck there, but they won't answer the door.
I'm now looking at the junkyard conditions. I mean,
The junk is simplistic because it's the plywood and the comforter on the front porch that's been there for 43 days.
yeah. He didn't sign for notice, did he?
Yes.
He did?
Well, I want to double check, but it should be in the packet
Yeah, no, I was just curious.
for the notice of hearing.
Yeah, it does appear that there is a signature. It's not the junk case of the century, but as often happens, for some reason, especially at the end of the hearings, I have to concede that, I mean, you're right, you know?
It's the ordinance. I mean, I go by the ordinance.
No, I'm a big believer in that, you know, the plain text, you interpret the statute. Let's see, so I see the registration on this car expired on September 2020. Is that a car or a trailer? Oh, it's both, you've got,
There's a blue trailer that's on the left hand of the property that looks like it hasn't been used in quite a while, but the truck, the pickup truck with the cab on top, that was there and then not there, and now it's there again.
Yeah.
So it was there on the 12th, and it's an expired tag.
right. Is the trailer a part of the case?
I'm gonna make it part of the case, because it's not tagged, and it's a trailer. So it'd be something you'd use on the road.
I mean, that's interesting.
Or I'll
So,
just use the pickup. I'll go with just the pickup.
It's up to you.
Then I'm gonna stick with the trailer, because it is a trailer.
I just want to look it up because I'm curious what it says about the trailer. Because if that's true and it is a violation, then you can't really store a trailer that's not tagged, right? Is that right?
If it's something that's gonna be roadworthy, it needs to be tagged and operable.
Okay, 20-41. It shall be a violation of this article for any person, firm, or corp to keep, dump, store, place, or deposit abandoned, unlicensed, inoperable, junked, disabled, wrecked, discarded, or otherwise unused vehicles or vehicles without a, and I know that we have established under the definition of vehicle. That's interesting. Is a trailer a vehicle?
I was thinking the same thing. You'd still need a tag for it if it was on the road.
It
but-
is a device designed to be moved upon a street or highway under the county definition. Okay. Then I will find that the property is in violation. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day with case number 23-1243, case number 23-1288, case number 23-1289, along with administrative costs to begin after the date you deem sufficient to abate these violations. This amount is appropriate given the severity of the violations, and the respondent's actions relative to these violations. And we would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
All right, I'll find that a violation has occurred in all three cases. On case number 23-1288 and case number 23-1243, I'll grant 14 days to abate the violation. If it's not brought into compliance as ordered, a fine of $100 per day. On the vehicle case, 23-1289, I'll grant 30 days. And if it's not brought into compliance as ordered, a fine of $100 per day.
Thank you.
Yep.
Next case, Carla Souza and Gina and Emmanuel Denuzio and Daniel O'Brien. Case number 2023-01128, Code Officer Brandon Norman.
Brandon Norman, Citrus County Code Compliance Officer. This is case 2023-01128, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. The address listed is 7271 East Turner Camp Road in Inverness, Florida, 34453. Property owner listed as Souza Carla, Gina and Emmanuel Denanzio, and O'Brien Daniel. I have good service via posting of the property in the Lecanto Government Building, and I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on November 7th, 2023, my corrective action inspection on December 21st, 2023, and photos of my final inspection January 16th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the posting affidavit that I completed, along with the photo of the posted notice of hearing of the property.
Yeah, no, I get it. Without objection, what's proposed as exhibits A and B are evidence? Wow. I mean, I'm not talking about the grass.
Yeah, the awning, I'm
Yeah.
kind of waiting for the awning to collapse more so I can run a junk case.
It's going. I mean, it won't survive the summer, I don't
Yeah.
think, but.
And a lot of the grass has been dying off with the cold, but it's
Yeah.
it's the rear of the property that's still severely overgrown.
Well, I see it. There's definitely a violation. You took these photos?
I did take those photos.
All right, what's your recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they revised the violation, and the amount is appropriate given the severity of the violation. We would also ask the special master find its respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection.
I'll grant 14 days, and if it's not brought into compliance as ordered, $50 a day.
Thank you.
Thanks.
Last case, Ellen N. Stark, case number 2023-01002, Code Officer Brandon Norman, page 30 of your agenda.
Brandon Norman, Citrus County Code Compliance Officer. This is case 2023-01128, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. The address is 6201 East Rush Street in Inverness, Florida, 34452. Property owner listed as Ellen N. Stark. I have good service via posting of the property in the Lecanto Government Building, and I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on October 9th, 2023, corrective action inspection on December 21st, 2023, and photos from my final inspection January 16th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the posting affidavit along with the photo of the posted notice of hearing.
Exhibits A and B are evidence. Thank you. You should really lead. I know that you have to move people out of here, but you really should be leading with the grass cases. That'll increase your viewership on YouTube.
Is that what we want?
Yeah.
This one initially, the front yard was overgrown, so I was able to measure it, but as it got colder, it died off. But again, it's the side portion that's
Well,
really
I
still overgrown.
still see some overgrown stuff even in the
Yeah.
front yard. I mean,
It's just not as severe anymore with the cold.
Contact with the property owner?
No contact. I've left door hangers. I even canvassed the surrounding homes.
Yeah.
Nobody knows. So.
Nobody knows her?
Well, nobody knows how to get in touch with them.
Oh, okay. I mean, they don't see her?
No, I've never seen a car there at all.
Wow.
It's not in probate or anything. So.
Yeah, that's why I ask. Doesn't look like much is going on. No flag flying. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to abate this violation, or to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they're revised. This amount is appropriate given the severity of the violation as well as the respondent's actions relative to this violation. We'd also ask that you make it the respondent's responsibility to contact us once the violation has been abated in order to allow for reinspection.
Because there are no signs of life, I mean, I'll grant 30 instead of 14 and days to bring it into compliance. If it's not brought into compliance, $50 fine per day. And I think that was the last case on the agenda. Is there anything else that the county wants to bring up while we're all here? Okay, then the time is 1:22. This hearing's adjourned.